to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. The sweet peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when sweet peas in the building, we be learning with pride. Minds on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Light you with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial, trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made a goal. Hey! Take it to trial, from day to night and every wild mile. Sweet Pea's nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
Good morning, good morning, good morning, good morning. Got remix. I forgot it's on like a loop track. Good morning, everyone. Good morning. So today we are getting into the defense portion of the case. Hopefully everything is going well with Mr. Cruz. Good morning, moms of the world. Good morning, Merelda. How are you? How's everybody doing today? Thank you guys for joining me. Oh gosh, what is that? They like every morning, like some of these things that you sign up for, they're like little stalkers almost. Okay. Okay, yeah. I'm not trying to share it just yet. So I'm going to put a couple polls up. So last when we left off, the defense had asked for a direct verdict on some items. Of course, they were all denied. But I think that some of the items that they were requesting a direct verdict on, they really didn't have direct evidence. A lot of the things was inferred. Some things were inferred evidence. And I'm not sure why they didn't get a direct verdict on those things. Like, say, for instance, the house fire. They don't have any direct evidence. They just inferred that because these things happened that he had to do it. Just like the knife. They don't have any direct evidence tying Mr. Faust to it. So they are just inferring. And from my understanding, when you are inferring, because I was trying to figure this out. I'm going to become a YouTube professor in the law. But when I was looking at it, good morning, SD. When I was looking at it and I was like, okay, well, when you inferring, that means that that you shouldn't be, that the judge shouldn't be considering it. But this judge, she want to act like she's not considering none of the evidence when she made her decision on regards to a direct verdict or not a direct verdict. But yeah, wow, interesting. Well, thank you, thank you, thank you. I appreciate you for listening wherever you're at, babes. So I think some of the items they should have received a direct verdict on, but this judge wasn't going to give them a direct verdict on anything. She like, if one thing happened, all of them happened. Basically, is what I got from it. And even when the defense was presenting it in light of most favorable to the prosecution team, and that's what he did. It's still, the things that he did, provide toward, um, didn't help in that way either. So right now, currently, day 9 has not started just yet. We are still waiting for the courtroom to go live. In that event, I'm gonna get that up in the background so that way we can see it and know when it actually goes live in the courtroom. We do have our sentencing for the all pair trial that is supposed to begin. That will begin about 9:30. I do have a little clip. The judge was speaking last night on that case. She's going to be retiring soon, and I'll pay her clip when we go into that one. Right now, I'm checking the court documents to make sure we don't have any new information. It's like my screen is too bright or something. Let me see if I can dim my screen because my eyes are hurting. Okay. Let's see if we have any new documents. The only new document besides the Sweeney document that we seen yesterday is that there was an appeal filed on behalf of Ahmad Cruz for his first amended notice. Let me see if I can get that up here. I think so. Let me get that up here. We can look at that. So this was filed on February the 11th, 2026. This notice entitled the First Amended Notice of Intent to Appeal is submitted as a replacement of the notice of appeal filed on February 8th. And y'all recall, we read over the one from February the 8th. This is where the attorney Cruz is wanting to fight being held in contempt and a $1,000 fine. Okay, so it says the clerk will please take note of the following items should be included in the record with the appeal. So they want to put in this appeal summary like this contempt of court may have been a little biased, a little overreach, a little overkill, and may have been instructed to be handed down to Mr. Cruz due to probably some past history with them guys, with him and the judge. It says transcripts of opening statements from February 2nd, 2026. So these are additional things that he wants to include, including the objections, argument, and ruling by the court done during the appeals in both outside or within the presence of the jury. Also, he wants to include the transcript of the hearing of the state's motion in limine to exclude on January 21st, 2026. He wants also in this appeal that he's doing the transcripts of the motions hearings held on January 23rd, 2026. He also wants the state motion that was filed October 2nd, 2025, entitled State's Motion of Limine to exclude irrelevant prior SA history of the victim. Motion to compel pretrial notice of the defendant's intent to introduce any evidence pursuant of OCGA 24-4-412, and a motion and notice of, I don't know what this word is behind this, a notice of intent to present evidence of specific instances of the victim's sexual behavior with respect to another person. So I guess her behavior. Defense motion to present testimonial evidence pursuant to that 412. Handwritten order granting the state's motion to limine, filed, stamped January 21st, 2026. A motion of reconsideration of the Honorable Court November 13th, 2025 order denying all of Mr. Faust's motions to suppress. A motion to disqualify, recuse, get rid of Judge Lisa Lott from all further dealings in the above references. Case filed January 16, 2026. Remember, we went over that order to recuse, which was denied, right? An order denying the motion to recuse, that was filed on January 1st, 2026. A contempt order that was filed on February 2nd, 2026. No other portion of the record is to be included with this appeal. So they want all of this stuff to be included with this appeal that they're going to be sending up to the Supreme Court of Georgia in regards to seeing if Mr. Cruz should be liable for this, liable for that contempt. Okay. So we'll keep an eye out on the documents. And this was submitted by Russell Gabriel, and this is attorney for Movant, and that's his bar number. And I think he must be another attorney that's representing our guy, Mr. Cruz, in this appeal. So shout out to them. Okay, so I do hear movement in the courtroom, so we'll go ahead and get right into the courtroom. Don't want to miss a minute of this action and want to get it right on time. Good morning, Christine. How are you? So let me get us in the courtroom, and let's see what's going on today.
You had said you were going to keep us posted. I sent out an email, not only talking about court, but also needing the information for your WebEx witnesses, and we heard nothing, which was a bit unusual. Right. I just assumed Mr. Hill would respond since he's attorney of record also. And I don't even see him this morning, but I put him on the email too. So I thought he would communicate with the court. Okay. All right. Thank you. All right. Are you ready to proceed, Mr. Cruz? Well, we got to get into some issues before we do that. So, all right. So the first few things are this. This gentleman sitting right here, I need to know, is this young man an attorney? Okay. 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 Well, I understand that, but they are not allowed at the table during trial. So you're going to have to sit back on the benches. The other issue that I want to discuss, you both are going to have to sit on the benches. It is not allowed to have non-attorneys who haven't entered an appearance be at the trial counsel table. No, sir. They need to be back. The other thing is that one of the issues that I wanted to raise to make sure we're all on the same page, and this gentleman right here, I don't know your name, sir. I'm sorry. What's your last name? Evans? All right. Mr. Evans and Mr. Cruz, I know that you needed some information from Charlene Satterfield, who is our court reporter. You asked her when we were on a break, both of you at different times, for information for her to play back things from the record. That's not appropriate. We are in trial. If you need something from the record, it has to go through the court. And I want both of you to understand that it's definitely not acceptable for a paralegal to make a request like that at all. But it's definitely not appropriate for an attorney to do that without going on the record, either making a motion, asking the court, things of that nature. All right, thank you. All right. I have the jury coming in later, and so this is the time for us to take up some other matters. We've just gotten the state's charges. Mr. Cruz is sending the charges to Miss Ellis, so she's going to get those compiled. Counsel, what we typically do, and good morning, Mr. Hill. What we typically do, and counsel for the state knows this, but counsel for the defense needs to understand this, is we will send you all a copy of the combined charges in one big document online. You'll get that on your email. So hopefully it'll be easy for you to look at it. When we do our charge conference, we'll print the entire thing out. Everybody will have a copy. We go through from front to back. So for Mr. Cruz and Mr. Hill, on jury charges, I always include for the court's charges, the standard charges that every superior court uses in every criminal trial. And so all of the definitions, for example, for reasonable doubt, for just as an example, evidence, the burden on the state and things of that nature are always included. You certainly can include those in your charges. If you don't agree with how the court does its typical charges, we'll certainly consider whatever you present. But I just want you to know, if you want to bypass the typical charges that are involved in every criminal trial, you certainly can do so and focus on the charges that are in the indictment. So that's kind of our process. I don't know when we're going to get to that, but I want to make sure you all know that it's going to be a big document for you to look over, and we sort of go through it page by page. All right. Let me ask the state, are there any other issues the state needs to bring up? I want to talk to Mr. Cruz about his timeline in just a second.
Your Honor, we'll have a couple of different motions in limine that we would ask the court to consider this morning prior to witnesses taking the witness.
Okay.
Whenever you would like to do that.
Mr. Cruz, I'll hear from you in terms of your witnesses. We're going to need certainly the information for your WebEx people. And so I'll hear from you in terms of your witnesses, how long you think this is going to take. You may not know, but if you have any idea of where we're going, certainly.
I think we'll be done by noon. I still have to talk with the team to figure out exactly what order we're going to put individuals in.
Okay.
As far as the WebEx information, I can provide that to the honorable court now.
Okay. We're gonna get. It's one of the reasons why I have the jury coming in a little bit later this morning, is we need to get that set up because I didn't have that information yesterday. So if you can actually send that by email right now to Miss Ellis, we're going to get that to Miss Craig, who is in the other county. She's in Oconee County, helping to handle court out there, and we will get her to set it up.
And I need to call her. She's not local. I think I advised honorable court of that, so I need to call her just to let her know that
when we're ready to roll. Sure, absolutely. But if you'll send the emails where we need to send the WebEx, I think we'll put both of them on for the same time. Well, I don't know if we should do that. Let me think. Let me ask you this, Mr. Cruz. Do you already know the order of those witnesses? Which one's going to go first?
I don't. I need to speak.
Okay. All right. I'll let you do that. Do that and let me know. I think I'm just sort of thinking out loud. I think that's better for the WebEx, that we'll try to do it in the order that you're going to call them. So they're not both on the same WebEx at the same time.
Okay.
Yeah.
We'll wait to the motion in limine because that.
Okay. Sure. All right. Very good. Any motions you want to present, Mr. Yalmanchili?
Yes, Your Honor. Thank you. My understanding is, at least in part, we're not sure who all of the witnesses are going to be that Mr. Cruz calls, but it is my belief that he intends to recall Detective John Newton, as well as call Detective Mike Tyndall and Kashana Armstrong. As it relates to Detective Tyndall, the state would make a motion in limine regarding any testimony about alternative suspects other than Mr. Melton, as has been referenced several times during the trial of this case. In pretrial motions, the state filed a Saudi motion. Mr. Cruz identified only Chris Melton as an alternative suspect that the defense would offer before the jury. Detective Tyndall, I think it's actually Sergeant Tyndall, if I'm recalling correctly, is a law enforcement officer now with the Oglethorpe County Sheriff's Office. At the time, he was with the Athens-Clarke County Police Department. In part, he interviewed individual by the name of, Stephen Barden, who was a law student at the time, and he also interviewed an individual by the name, I believe, of Anthony Little, who was a resident of Athens-Clarke County at the time. These individuals were interviewed as initial persons of interest, but no evidence was ever developed to link them to the crime. And therefore, in addition, Mr. Cruz hasn't provided notice through in response to the state's Saudi motion, so no evidence of anything related to those two individuals would be relevant, and under a 403 analysis would be confusing and misleading to the jury. So we would make that motion in limine. Also, it's our belief, and obviously we do not know this for sure, that Mr. Cruz may be intending to attempt to question Mr. Newton and Sergeant Tyndall regarding certain phone records for which there is no records custodian who has appeared on the witness list in order to testify to authenticate those records, and no notice of intent to introduce the records without a records custodian has been filed. Obviously, we ran into this issue with another witness, which is why the state is making a motion in limine at this time that those records should not, these witnesses do not have the ability to authenticate those records in an appropriate way to lay the foundation for their admissibility. And so those records should not be used as a methods of questioning these witnesses or raised as far as their contents in reference to the questioning that Mr. Cruz would do, or, even if they're not admitted into evidence, the information in them cannot then be used in the questioning in an effort to introduce hearsay evidence through questioning of witnesses who aren't able to lay the proper foundation for the admission of those records. So those are the motions in limine that I wanted to present, Your Honor. And I know that the way we've split up the cross-examination of possible witnesses that Mr. Cruz may call. If I could have just a moment to consult with Mr. Bolden.
You can. But you were talking about the phone records with regard to the witness. Mr. Cruz is calling Sergeant Tyndall. Is that right?
Sergeant Tyndall and Mr. Newton.
Oh, and Mr. Newton. Okay.
In the recall, I believe there was an attempt the first time that Mr. Newton testified in order to introduce those business records, and the court made a ruling that there was not a proper foundation laid for their admission, and then they could not subsequently be used in the manner that Mr. Cruz was attempting to use them, basically making a motion in limine to continue to adhere to the court's earlier ruling and prevent that process from playing out in the exact same way again. And then it's a similar argument with Sergeant Tyndall, because I think that those two witnesses are similarly situated. as it relates to the phone records and their inability to testify to foundation for admissibility of those records.
All right. Thank you. And you may have a moment, Mr. Bolden, and then I'll hear from you, Mr. Cruz.
Okay. Your Honor, Mr. Bolden will be making a motion in limine as well.
All right.
Morning, Your Honor.
Morning.
Yes, Your Honor, just to kind of piggyback on what Mr. Yalamanchili was just discussing, this is specifically as it would relate to John Newton's testimony. One of the things that the state expects that the defense may try to elicit through its direct examination of Mr. Newton is the fact that he had a conversation on January the 25th of 2001 with an individual by the name of Jessica Gann. That's Gann. Miss Gann, I believe, well, what's in the report is that she called and spoke with then Detective Newton on that date, on the 25th of 2001, January the 25th of 2001, that she was at Mexicali Grill over on the east side near Kroger, and she heard some girls in the bathroom talking about law school. They appeared to be drunk. This was at about 9:30, and she thought one of them may have been Miss Baker. I think Mr. Cruz actually referenced that in his opening statement. The state would move to exclude any testimony by Mr. Newton as it relates to his conversation with Ms. Gann. First of all, it would be hearsay. And second of all, even if there were an argument that it is not hearsay, and I think that frankly, the analysis should end there. But even if the court were to find that it is not hearsay or it is an exception to hearsay, at this point, we would object on grounds under 401 and 403. It's not relevant, and any conceivable relevance is substantially outweighed by the risk of confusing the issues and misleading the jury. And in that regard, I would point out that the uncontroverted evidence at this point, in the form of the testimony of Ms. Lonstein last week, was that Ms. Baker was in the law school library until at least 9:46 when Ms. Baker called her to make sure she got home safely. And so the idea that she could somehow simultaneously be at a Mexican restaurant on the east side under the influence of alcohol is just not borne out by the facts. So the state would object to any testimony, any attempt to elicit testimony from Mr. Newton regarding that conversation.
All right. Thank you. Anything else?
No, Your Honor.
All right. Mr. Cruz, several motions on the table. Go ahead, sir.
The only two that I'll address is first I'll start with, and good morning.
Good morning.
Board. First I'll start with Stephen Barden. I do intend to introduce that evidence, Your Honor, and not for the purposes of showing him as an alternative suspect, but for the purposes of showing that they had Mr. Chris Melton and this evidence leading to Mr. Chris Melton. And instead of executing a search warrant on Mr. Melton, the investigators decided to terrorize Mr. Barton and execute a full-blown search warrant on his house, obviously because he had nothing to do with Ms. Baker's murder, turning up no evidence of a murder. But these same actions were not taken with Mr. Melton. So the sole purpose of that testimony would be simply to, as we stated in opening, as we've maintained this entire trial, just to show that this investigation was not thorough. It was directed away from Mr. Melton at every twist or turn. In regards to Mr. Newton's testimony, in regards to Jessica Gann, as far as hearsay, we're not offering Jessica Gann's statements for the sole purpose of the truth of the matter asserted. Similar to the questions we asked about Ms. Keshana Armstrong, we're offering the information about Ms. Gann again to show that the investigation was not thorough, the early investigation. Law enforcement was aware of this information. They did not provide Ms. Gann with a photograph of Ms. Baker. They did not do any type of, I don't want to say a lineup, but they did nothing to follow up on the information with Ms. Gann. They got the information, they just ignored it and moved on. And that information also impeaches the state's position. The state's position is simply that because Mr. Faust's DNA is present, that means he's responsible for every single count in the indictment. One piece of evidence they have not shown haven't presented anything showing where Miss Baker was the night before her death outside of the library. And in regards to the timepiece, I think that's more appropriate for cross-examination as opposed to a motion to limine. And the reason why, Your Honor, is the state has defended multiple witnesses on their time discrepancies, even time discrepancies that occurred closer to the crime. I believe Ms. Gann might have been interviewed, I believe it was 7 days after. So if she wanted to give and I believe the state made this argument in regards to a particular witness. I can't remember the witness, but if she wants to make an approximate time, hey, I believe it was 9:30, maybe 10 o'clock. I don't know what she said because we only have the report, but I believe it was around 9:30. That's something they could flesh out with Detective Newton during cross-examination, Your Honor. So those are the only two motion to limine we would seek to address with the Honorable Court. In regards to the phone records, the Honorable Court knows my position with the records. I respect the Honorable Court's ruling. I think you've made it clear that we are not to present any phone records of anybody at any time. So that's the issue that the Honorable Court has already ruled in the state's favor on. So we disagree, but we follow the Honorable Court's ruling.
All right. Thank you, Mr. Cruz. I'll start with the phone records. The issue with the phone records was not necessarily a blanket instruction to prohibit testimony of phone records. The ruling was based on the lack of defense counsel's, for whatever reason, lack of providing the proper witnesses to bring those phone records in. And without the proper witnesses subpoenaed by the state, phone records are not allowed under law. And so that's the ruling I made. I want to make it clear for the record that the court's ruling was not a blanket. The defense cannot bring in phone records. Certainly, there might have been, if you had subpoenaed the proper people to bring them in, we could have had another hearing as to whether they were relevant. I mean, I'm not making a comment that they would necessarily be admissible, but just the ability to talk about them is based on the lack of ability to produce the proper foundation. I know we argued that at the bench, but I want to make that clear.
Can I respond to that?
You may.
The state, we had a hearing on this. I asked for out-of-state subpoenas regarding the phone records. I advised the Honorable Court at that hearing that Sprint, and I believe, I can't think of the other company, but the companies were out of business. They sent me emails stating that because the records were so old, they did not have a way to verify those records. The state explained to the Honorable Court that they would I'm looking for the proper word, but I don't have it now. So I just say they would agree that for foundation purposes, the records are admissible. They said they would object on hearsay grounds, things of that nature. But our argument was that the records aren't hearsay because they are computer-generated records as opposed to a statement by a person. Just to put that information on.
Well, let's talk about that because we did have a hearing with regard to those issues. There are a lot of phone records that we were sort of talking about at the time.
Right.
So let the state respond. We can talk about that. Go ahead.
I'll be happy to respond, Your Honor. With that hearing did occur. At that time, we had been in for several weeks, I believe, attempting to discuss and lock down stipulations with Mr. Cruz. And it was the state's belief at that time that we were going to be in a position where Mr. Cruz was agreeing to stipulate as to the foundation for certain crime lab reports. And in exchange, the state would be willing to stipulate to certain phone records and also crime lab reports from North Carolina in the form of some mitochondrial DNA analysis. However, Mr. Cruz never gave the state a response despite repeated requests to give us an answer as to whether or not we had stipulations. I drafted a list of proposed stipulations and I gave them to Mr. Cruz in the form of a physical document, I believe on the first day of jury selection. After reviewing that document and consulting with Mr. Faust, Mr. Cruz informed the state that at Mr. Faust's direction, the defense was refusing to stipulate to anything. So an offer was made and denied by the defense. And at that point, there were no stipulations, and the state has endeavored to call the appropriate witnesses to admit the evidence that it intended to admit via stipulation, and was certainly something that was available to the defense as well. But as the court noted, for whatever reason, those witnesses haven't been present in order to lay the foundation. So that's the context in which stipulations were discussed and then refused by the defense.
All right, thank you. Anything further, Mr. Cruz, based on Mr. Yellman-Shilly's comment?
No, ma'am, that's accurate.
Okay.
We refused
Okay.
stipulation
Okay.
made by Mr. Yellman-Shilly. Correct.
All right. Thank you, sir. So I think based on that, and I do remember certainly the hearing, I can go through and look at my notes. They aren't in front of me at the moment and the order that the court signed. But I would just say, I mean, I'm going to grant your motion with regard to the phone records, Mr. Yellman-Shilly. I think that is appropriate legally at this point. If a stipulation is not entered, as was announced in court, that you all would be able to work that out, the court would have had to know that in order to specialize or set a special time, I should say, to hear the rest of your motion, Mr. Cruz, to decide whether your motion was appropriate and whether what you were asking for could be granted. And that hasn't been done. I can't do it certainly in the middle of trial. So I'm going to grant your motion with regard to the phone records. With regard to any testimony from Mr. Newton with regard to a witness that you wanted to call, Jessica Gann, let me ask you this so I'm clear on what you're saying. Well, let me just ask you, what is your position on the state's objection about hearsay? Yes. I mean, they've objected on other grounds as well, but what about the hearsay?
It goes to notice. That's my response. It's not hearsay because it goes to notice. That law enforcement was on notice about this information and they didn't follow up on it. We're not offering for the truth of the matter. We're offering it to show law enforcement, which is one of our multiple defenses in this case. I think a big part of the state's case is that law enforcement had information that they just failed to follow up on that would have resolved this case 20 years ago. So it's just notice. This goes to notice that law enforcement was aware of this fact and they didn't follow up on it.
Right. Thank you, sir. I think at this point, what the law would require, Mr. Cruz, is that if the defense's argument is that these statements that certainly I would say at this point would confuse the jury about anything that may have happened at a Mexican restaurant with a person's statements who have not been elicited in court at all. I certainly would say that under 403, we are talking about confusion of the issues and misleading the jury. I think that's certainly a problem. But I would say that at this point, Mr. Cruz, the defense would have to provide evidence to what you've just stated. I mean, a blanket statement that you're making that if law enforcement had followed up with Jessica Gann, this case would have been over 20 years ago is that's a pretty spectacular statement. And in order to ask the court to admit those statements in lieu of that comment, the defense has to provide the court some evidence that that would in fact have been true. And without that evidence, that testimony that you are seeking to elicit, certainly I would say falls under the category of misleading the jury, of confusion of the issues. And it really does come close to that line that we have been discussing this entire time, which is the order that there are to be no statements by witnesses about other suspects other than Chris Melton, which you properly gave notice to the state for. So, you know, you certainly can respond to what I've said, and then we're going to kind of move on, but go ahead.
So two things. My statement, I think I may have said it wrong to take it out of context. So my statement wasn't, or it should not have been, forgive me if I said it this way, isn't that, hey, if they solely would have talked to Jessica Gann, this case would have been resolved. I believe I stated it the wrong way. What I was saying is if law enforcement would have followed up on all leads, this case would have been resolved. As far as the 403 ruling, Your Honor, the state didn't object on the basis of 403. I understand the court could make any ruling that it deems appropriate, but the state did not object on 403 grounds. The state objected on hearsay grounds, and we provided our response to the hearsay. I would like the opportunity to provide a response to the Honorable Court's objection regarding confusing the issues for the jury.
You certainly can. I thought Mr. Bolden did make a 403 argument, and that's fine. I'll let you respond regardless, but I think he did. But the court has an obligation, regardless of whether the state or the defense talks about 403, the court has an obligation to respond to 403. So you certainly can respond.
Sure. So in regards to 403, as far as confusing the issues, this statement from Detective Newton wouldn't require a mini trial to determine facts of issue. It's simply a building block on the facts in this case that support our position. I don't think that one fact I think we're on the 9th day of evidence, maybe? We're on the 10th day of evidence. We started last Monday, if I'm not mistaken. That one fact out of 10 days of evidence, I don't believe that will confuse the jury where they say, hey, we don't know what the heck is going on in this case. I can't believe Jessica Gann said that she saw Miss Baker. So that would be my response. I do not believe that one fact would confuse the jury, Your Honor, and I'm not sure. Did you say waste of time also?
I did not.
You said confusion of the issues and one more.
Misleading the jury.
And my argument would be the same. I don't, out of 10 days of testimony, and of course, the Honorable Court has all the wisdom. I don't believe that one fact would mislead the jury to making a decision in regards to the indicted charge, where they say, we have this fact. Now we don't know if Mr. Faust is innocent or guilty because of this one fact. So I asked the Honorable Court to reconsider its ruling under 403.
All right. Thank you, Mr. Cruz. I mean, I think the argument you've just made supports the court's conclusion that any evidence regarding this Jessica Gann person, first of all, it certainly sounds like hearsay. I understand what you're saying, Mr. Cruz, that you're not offering it for the truth of the matter, but I think there's an argument to be made that you are, but I'm not finding that it's relevant. I think at this point, given the comments that both counsel has made, it would be incumbent upon the defense to provide evidence as to why any testimony by Jessica Gann would be relevant. And so I'm going to grant the motion. I'm going to find that it is not relevant. It is hearsay, and there's no exception to overcome the hearsay. Under 403, I certainly do think at this point, bringing in another person to suggest evidence that is not supported is a very significant moment of misleading the jury and confusion of the issues. And so under 403, I'm going to grant the motion as well that Mr. Bolden has made. There will be no testimony allowed to be elicited from Mr. Newton about Jessica Gann. No testimony elicited from Sergeant Tyndall regarding contents of phone records unless you can present a witness that can lay the proper foundation. Let's make this clear, though. I want to talk about this. Is there an objection from the state? Let's do this right now about Mr. Cruz asking Sergeant Tyndall whether he was able to get phone records.
And that's what can I respond before this? He
Sure.
laid the foundation for the phone records.
Sure.
The court order he obtained via recognizing the phone records, via stating that
Right.
those phone
Right.
that they didn't appear to be altered. So he laid the foundation
Sure.
for the records that he received.
I remember that. I have that in my notes. But let's just get this out now so we're not having any, problems
I
later.
do not believe that there is anything wrong with asking Sergeant Tyndall if he obtained phone records. However, whether the police officer got phone records back as part of his court order is not the proper foundation for admissibility of those phone records.
I understand.
And so that's what our objection is to the
But
contents.
in the
The
context.
fact that he did in fact seek a court order, that the phone records were provided, are things that I think are appropriate questions that can be answered. It's just that any contents of the phone records cannot be asked about without the appropriate foundation witnesses, as the court's already articulated.
All right. Thank you. So I want to make sure, Mr. Cruz, do you have anything else you want to say about that or any questions for the court? I mean, I do think that's right. And Sergeant Lieutenant Tyndall has already testified, as you said, about those records. They are in my notes. Again, I don't have it in front of me, but was Newton? Yes, ma'am. Yes, ma'am. Sure. Got the microphone again.
Newton
All right.
was the
It was Officer Newton.
I don't believe Tyndale has testified at this moment.
That's right. It was Officer Newton. Okay, so let me just make sure we're clear. And I do recall the testimony. It was Mr. Newton, former Officer Newton. Are you intending to ask Sergeant Tyndall about phone records as well, obtaining phone records?
I am only going to ask Sergeant Tyndall about things the honorable court permits. From what I understand right now, that is not permitted. So no, ma'am.
Well, that's why we're having this discussion. I mean, I think the question as to whether an officer in his or her investigation received phone records is certainly a permissible question. And I agree with the state's characterization of that as being admissible. I think it's the contents and the admissibility of what's in the records that's at issue. So let's
Right.
just flesh this out now, make sure we're on the same page.
So the contents, that's what's important to us, because I think it will establish the nature of Mr. Melton and Ms. Baker's relationship up until the day before her death. If the honorable court's ruling is that we are not to get into the contents of the phone records, and of course we put our response to the state's hearsay objection in regards to the phone records, so I won't go into that, Your Honor. But if the honorable court is saying, hey, my ruling is that you cannot get into the contents, you cannot talk about the phone records with the witness, I won't get into that.
All right, thank you, sir. All right, so I'm not changing my ruling unless I'm presented with some other piece of information that is appropriate for the court to change its position without the proper foundation to be laid with regard to the contents of the phone records. They're not admissible in terms of the content.
Well, I do want to say this just to make it clear for the record. The foundation was laid by Mr. Newton. I think the disagreement between me and the state is saying it's hearsay, and I'm saying that is non-hearsay because they're computer-generated records. That's the only disagreement. And of course, the honorable court issued its order on that. Sure. I just wanted to make that information clear.
All right, thank you. So it doesn't overcome the hearsay because there does need to be a foundation laid in terms of the contents of the record. And so of the records. I'm not going to change my order on that. A foundation has to be laid. They are hearsay. And unless the witness is a custodian of those business records, can testify to them as would be required under law, I am going to rule that the contents are not admissible. The questions about whether an officer received phone records is an admissible question. Mr. Yelmichilli, did you want to add something before we finish this phone records conversation?
Just briefly, Your Honor, I'm sorry, I should have mentioned this before. We would, although it's perfectly fine as from the state's perspective for Mr. Cruz to ask about whether or not Sergeant Tyndall or Mr. Newton received phone records, we would say that any affidavits that were submitted by the law enforcement officers in order to receive the court orders to get the phone records and the court orders themselves, I don't think are admissible as evidence, as substantive evidence in the case. Just the questions are appropriate, but I don't think those documents, as far as the affidavit, would be admissible and would be able to be submitted to the jury.
Okay, and tell me why you don't think they're admissible. What would be your argument?
Well, Your Honor, those affidavits are within them going to necessarily contain some hearsay information, since they are, the officer's statement and affidavits for purposes of receiving court orders or search warrants are not limited by the rules of hearsay when they're being submitted to the judge. Now, if there were certain portions of them that serve to contradict testimony that the witness gave about things they did or did not do, then they may be admissible for the limited purpose of impeachment on those issues. But just simply tendering a law enforcement officer's affidavit, I do believe would contain hearsay statements within it, and also contain, their opinions on certain things and various other things that wouldn't necessarily be admissible in the context of a trial before a jury, although they would be appropriate for the purpose of having obtained the court order to begin with.
All right, thank you. Mr. Cruz, care to be heard on that?
No, ma'am.
All right. Then I think that's right. I mean, that's, I think, a correct statement of the law. I would say, however, in the same vein as questions about did you obtain phone records is an admissible question. I think certainly, and I'm not telling you how to do your examination, but if you chose to ask the officer, did you seek a search warrant for phone records, that is an admissible question. And unless you want to be heard on that, Mr. Yelmichilli, I want to make sure sort of we're clear that there are certain things you certainly can ask law enforcement about their investigation, and asking for a search warrant and did they go seek one is an appropriate question. I think the contents of what they received would probably not overcome a hearsay objection. If you feel otherwise at the moment, we can take it up outside the presence of the jury. All right. With regard to Kishana Armstrong, or is it Keyshawn Armstrong? Kishana. All right. There was a motion in limine regarding any comment about another person with a name. Was it Scott? Was that? Hold on just a minute. Let me make sure I've written this down right. Did you make the motion about Ms. Armstrong? Was that you, Mr.?
I don't believe the state has any motion in regards to Ms. Armstrong.
I wrote down Ms. Armstrong. I thought there was something about Mr. Another person who they did not. You didn't bring evidence. Bolden, is that correct? Or Bolton?
I hope not.
I'm sorry. Was it Bolton?
Barden.
Barden. Sorry, Barden. Okay. I'm not sure I wrote it down. And you were expecting that information to come through Ms. Armstrong's testimony?
Well, no, Judge, it was Sergeant Tyndall.
That was Sergeant Tyndall. Okay.
Yeah, it would be Mr.
right.
Barden and then also an individual by the name of Anthony Little. These would be two people that were considered persons of interest at the time. However, no information was developed to link them to the crime. And it was our belief, or at least we thought it might be a possibility, that Mr. Cruz is attempting to elicit testimony regarding those individuals from Sergeant Tyndall or Mr. Newton. I mean, just our motion in limine has to do with those two individuals just being mentioned in any way, since Mr. Cruz did not identify them as individuals he intended to raise as alternative suspects in response to pretrial motions hearings.
All right. Thank you. All right. I don't know why I wrote Ms. Armstrong's name down, and we have to get her WebEx information. That may be why I wrote it down. You have the information. Fantastic. All right. Mr. Cruz, do you care to respond any further with regard to the remainder of the state's motion in limine as it concerns any person by the name of Baden and Little, last names?
Baden and Little?
Baden and Little. They were just referring to two. Barden? I'm not going to get it right. Barden. Sorry. Barden.
I believe I put that information on the record for the honorable court, our position, that nothing changes from our position.
Okay. All right. Thank you. I'm going to grant your motion. It does violate the Sadi motion the court has granted in previous hearings and that we have been discussing throughout the course of this trial. And so I'm going to grant your motion. There will be no testimony about anybody by the last name of Barden and Little through Sergeant Tyndall or Mr. Newton. It would violate the court's previous ruling. So, all right.
Your Honor, I hate to jump in on that. There was another piece of this that I think because Mr. Yalamanchili and I are kind of splitting up potential defense witnesses today, Mr. Newton also spoke with an individual at the Clark County Jail back in March of 2001. That person provided some other names of people who were allegedly making admissions or whatever about being involved in this crime. The inmate with whom Detective Newton at the time spoke, her name is Melinda Thomas. The information she provided is secondhand hearsay about what some other people would have told her. These are not as it relates to Mr. Little or Mr. Barden, but under the same theory, the state would ask that any testimony about these other alternate perpetrators or potential alternate perpetrators also be excluded.
All right. Thank you. Mr. Cruz.
Just for clarity, Your Honor, and I may have said it wrong or misspoken.
Okay.
But these individuals, I'm not saying they committed a crime. I understand the state's alternative perpetrator ruling. I'm not saying any of these individuals committed a crime. So I may have explained it wrong. The purpose of Steve Barden is to show the investigative steps. It has nothing. Our position is firm. Chris Melton committed this crime. We're not saying anybody else committed it. So if I say something that sounds like I'm saying, Judge, we want to point the finger at this person, we want to point the finger at that person, I'm just misstating. That is not what I'm saying. Anything that we're seeking to bring in at this point in our case in chief is to show the failures of the investigation. They have nothing to do with whether a person committed a crime. They have nothing to do with hearsay. It's just whether, did you have notice of this fact? Did you follow up on this fact? If not, why? That's our entire theory with the witnesses. As far as the witness Mr. Bowden is speaking about, I just want to make sure we're talking about the same witness. May I see because there is one I wanted to discuss with.
All right.
So I, in fact, do intend to speak about Ms. Thomas. I wasn't going to refer to her by name. I was just going to say, did he speak to a inmate? And the purpose of this testimony is just to show, and I'll put it this way. It would be in serve rebuttal if the state has a rebuttal to our defense. So we wouldn't get into that information with Mr. Newton in our case in chief, but if there's rebuttal, this testimony will become relevant as serve rebuttal, depending on what the state's rebuttal is. So I would ask the Honorable Court not to make a ruling at this time until defense rests and the state lets us know if they are going to have rebuttal evidence in regards to the evidence that we present.
Okay. I'm not really sure I understand what you're asking, Mr. Cruz,
Sure.
about the rebuttal evidence, but I do want to respond to your arguments that relate to the state's. I'm actually looking for the order that I wrote with regard to this whole issue. Your responses to the state's motion in limine with regard to Mr. Barden, Mr. Little, this unknown person at the jail.
We don't have anything from Mr. Little. We didn't intend to elicit any testimony about Mr. Little.
Okay. But I'm going to mention this person in general because they all relate to the same thing. I understand certainly what the defense is saying about their position that the state law enforcement did not investigate this case properly. And I understand what you're saying about notice and that is those positions are the reason that the statements about other persons should be properly admitted. I understand what you're saying. The problem with that legally is this. The defense is asking for the court to allow it to go to admit those statements under that theory. And in doing so, that would bypass the court's order that it has already granted the state, which is that if there were any alternative suspects that were to be discussed at trial properly, the defense had to provide the proper notice, which would then allow the court to set a hearing so that we can determine whether the statements being offered about alternative suspects are admissible for lots of reasons, whether they would be admissible with regard to a hearsay objection, particularly whether they would be admissible because of relevance. And so just by stating, well, we're asking to admit those statements under a different theory, it is not appropriate for the court to allow that, because what that does is circumvent the prior order. They have to be done in conjunction. And so if the defense wanted to elicit testimony about other suspects for the purpose that you're asking for them to be elicited, notice under the Saudi motion we've been talking about had to have been done in order for the court to have in order for the state to have gotten the required notice, and in order for the the court to have set a hearing date in order to flesh this out. And that hasn't been done. And so I understand what you're saying, but it is not appropriate to circumvent the order by saying, well, it's just under another theory. That motion was not filed by the defense for whatever reason. And I'm not commenting on that. That may certainly be a strategic moment on the defense's part. But it hasn't been done. And because the proper notice hasn't been done, in order for the court to make a ruling that regardless of the state's feelings about those statements, regardless of any other legal objection that we've discussed in those hearings, those statements would be proper. The court hasn't had that opportunity because notice wasn't filed. So I'm going to grant the state's motion based on those for those reasons. All right, but I wanted to kind of make that clear. All right. Let me start again with the state. Anything else we need to take up before the jury comes back in?
No, Your Honor.
Okay. Mr. Cruz, is there anything else we need to talk about before?
Well, based on the rulings, I would like 10 minutes to talk with everybody because we have to figure out what.
Absolutely. So I think what we're going to do is this. We have your information for WebEx. We're going to go ahead and get that set up. I'm going to give you all till 10:20. Right. So that's about 25 minutes. I'll be back on the bench at 10:20, and then we'll get started. All right. We'll be in recess until then. Thank you.
Your Honor,
Yes.
I need to speak with Mr. Faust too, so he'll need to be a part of that discussion. Can we make that happen? Mr. Faust would need to be a part of that discussion as well.
He can absolutely can remain here. No problem.
I don't know what they doing. They just all seem like they confused to me. I don't know. I don't know if so we already know that the only person they can really point to is Chris being an alternative subject or alternative person that did this crime. They is no way that they're not allowed to question in regards to how bad the investigation was. Why? I don't know. I guess because maybe it gets a little messy and confusing for the jury. So it looks like that's part of what they're trying to do. But he's saying that they're not trying to point the finger at anybody else but Chris. Like, Chris is their guy. And if Chris was their guy, guys, they should have jumped on his neck when he was up there on the stand. And somebody mentioned to me in regards to him, he basically like admitted to doing it, or his destruction that he caused. Like, it was such a powerful moment that my guy didn't jump up on, and Mr. Cruz had to take advantage of that moment. But he didn't. So here we are. Here's a right every motion to the state. And see, that's what I don't, because I'm not an attorney, so I don't know. I did your poll. See, and I'm thinking that in regards to her rulings and everything, I mean, she knows that this is, yeah, well, I don't know. I ain't gonna leave it. I'll leave that there. The judge gets near on what the defense can present. In this case, she is not handcuffing and she's binding them. Yeah, their whole body, right? Well, about 20 minutes. You think she worse than Alicia? I don't think she worse than her. So I guess my question would be to us, because I don't know if we got any attorneys in here. Do you really think she biased, or do you really think that maybe the things that they are actually wanting to come in shouldn't be allowed? Like, maybe they are asking a whole bunch of stuff that cannot be coming in. I don't know, because I'm not an attorney, so I can't really tell. So I don't know. I don't like her, the way she says stuff is more my concern. As he said, she completely biased. I don't care what's going on. Yeah, see, I don't know, because if she's there to call balls and strikes. I mean, just giving her the benefit of the doubt. And I don't know, because I'm not an attorney, so I don't know if what she's calling, if it's right or not. I just don't like the disposition of it. I know the double hearsay one, it was good for them, but not good for another. I know that a lot of the motions that he filed were not addressed, so I don't know if that has anything to do with that part, because I'm not deep diving into the case. But yeah. But I did want to show you guys this just in case y'all missed this, because I missed it when we first looked at his testimony, and somebody had put a comment in the thing about it, and I was like, and we went back and listened to it yesterday, and I did make a little short clip of it. But I think that I want me personally, I want Mr. Cruz to play this. Like, I hope they hear me and they listening to me, but I want them to play this during their closing. I'm going to share it with y'all so y'all can see it for those that didn't see it. She worse than Alicia Andrews. Yeah, we know you feel that way. She got kicked off, right? Let's hope the jurors can see and interpret what's going on here. See, I think with Alicia Andrews, what I did notice is that a lot of things happen in the presence of the jury. I don't think she really doing a lot of this in front of the jury, but I could be wrong. There could be some parts where she did. I think she completely biased. Good morning, OnlyFan comes in and says, I love the judge. Honest. Yeah, I ain't going that far with it. Don't love her. I'm cool. Perhaps they had a history of disagreement. Well, they do got a lot of history there. And so, yeah. Ken Rosenberg could speak more on it if he can be ours. There are many attorneys watching this, and all of them have said that her rulings and all they say I can't say is what. Yeah, I have heard some attorneys' responses in regards to it. OnlyFans said he done seen worse out here in these streets. She totally helped to dismantle the defense case. This just feels totally unfair. I'm wondering the same thing. Michelle says she's wondering the same thing. Has the defense started? How many witnesses? No, the defense has not started, OnlyFans. We don't know how many witnesses. I hope they caught it. Can we see the clip of Mr. Cruz? Can we send the clip to Mr. Cruz? I don't know. Yeah, I hope he caught it. They haven't started yet. That's the answer to your question. Chris messed up when he said Tar didn't allow him. Oh, God, not the drainage. Good morning, John, with the drainage. Oh, boy. So let's listen to this clip that I think that they really should pounce on. This is the clip that SD wants us to see. Let me see.
To the house to identify her. And we were stopped at the door, I believe, by a fireman.
Wait a minute.
And I wanted to reach out to her parents and anybody I could get a hold of to see if they had been in communication and also to inform them of what had happened.
Did y'all eventually arrive in Athens?
Yes, sir.
Okay. When you arrived in Athens, where did you go?
When I was, what I can recall is when I was on the phone with Ms. Baker, I think Athens Clark County had reached out to her and she informed me of that. So I reached out to Athens Clark County and called, and I went straight to the police department is where I was told to go from the police department. They said, come straight here. And so that's where we were.
And I think that it's kind of indicated in your answer, but let me just ask it to clarify. When you say that you reached out to Athens Clark County, is there a particular department or agency or part of Athens Clark County that you reached out to?
Not that I recall. I think it may have just been like the main number at that time.
The main number for what?
For the police department.
Okay. All right. And so you went to the police department. At any point, did you leave the police department to go somewhere else?
Yes. Once I was there, they had asked me a few questions in a room, and then they asked me if I would identify her body.
What went through your mind when they asked you that?
I really did not want to agree at first because I was aware that there was a fire, and I didn't want to see any of them. You know, no matter who it was, I didn't want to see what devastation that may have caused. And it was difficult just to comprehend. And then the detective.
So right there, they are speaking in regards to when he is talking right there. That is a weird choice of words. He didn't want to go identify the bodies because he didn't want to see any of them and see what this devastation he had caused. Why would you have caused any devastation? Like, what does that even mean? Why would you even put yourself in that category? Like, I don't understand that. I don't know why he said that. Like, that's not something that a normal person says. That doesn't have anything to do with it. Like, you may not want to go see them for all types of other reasons, but for the devastation you may have caused, you didn't have anything to do with it, right? You're an innocent person in this case. What devastation could you have caused? Or was this a slip up on the stand, guys? You tell me.
Out to Athens, Clarke County. Is there a particular department or agency or part of Athens, Clarke County that you reached out to?
Not that I recall. I think it may have just been like the main number at that time.
The main number for what?
For the police department.
Okay. All right. And so you went to the police department. At any point, did you leave the police department to go somewhere else?
Yes. Once I was there, they had asked me a few questions in a room, and then they asked me if I would identify her body.
What went through your mind when they asked you that?
I really did not want to agree at first because I was aware that there was a fire, and I didn't want to see any of them. You know, no matter who it was, I didn't want to see what devastation that may have caused. And it was difficult just to comprehend.
So there it go again, that devastation that he had caused. So it don't make sense to me. Yeah, I can put on closed caption for it, and it's still the same thing. A devastation that he may have caused. So, I mean, no, if you don't have nothing to do with it, it's not the devastation that you may have caused. Like, that's not, I don't agree with subject to interpretation. I don't agree with any of that. He said that. Now, maybe he didn't, maybe he slipped up, you know, because his testimony, remember, it was rehearsed. Remember, he is the same guy that, you know, he was sitting up there really like trying to cry when Cruz was asking him about crying. So yeah, no. Let me play it again. I got the closed captions on.
Did not want to agree at first because I was aware that there was a fire, and I didn't want to see any of them. You know, no matter who it was, I didn't want to see what devastation that may have caused. And it it was difficult just to comprehend. And then the detective, he asked if I would identify the body because he did not want the parents.
Out to Athens, Clarke County, is there a particular department or agency or part of Athens, Clarke County that you reached out to?
Not that I recall. I think it may have just been like the main number at that time.
The main number for what?
For the police department.
Okay. All right. And so you went to the police department. At any point, did you leave the police department to go somewhere else?
Yes. Once I was there, they had asked me a few questions in a room, and then they asked me if I would identify her body.
What went through your mind when they asked you that?
I really did not want to agree at first because I was aware that there was a fire and I didn't want to see any of them. You know, no matter who it was, I didn't want to see what devastation I may have caused. And it was difficult just to comprehend. And then the detective.
Yep. So I got it where is the devastation that I may have caused. So I definitely think that with him saying that they should, even if you want to call it Mr. Cruz, yep, that's what I'm saying. Either way. You sent it to him for his consideration. He is a cop. He has had to see worse. Who's a cop, Tanya? You talk about the guy that was asking Chris to go, the cop that was asking him to go verify the body. So he did want to go see the house that was burnt, but he goes and identified the valley really. Yeah, I think that I just thought it was interesting. Yeah, I thought it was very interesting that came out of his mouth. His testimony was so rehearsed that I mean, what can you? I mean, besides catching him in the little small things that where he's slipping up and he hadn't rehearsed it all the way down to a T, because certain things he couldn't rehearse down to a T clearly, right? Because he slipped up and said that. Because I don't think in a million years he wanted to say that. That's too close for comfort. Even if he was saying I, it, they, he, she, woulda, coulda, shoulda. He came too close to that one. He should have probably took a couple of those deep breaths that he was taking throughout his testimony and did it there. But just so y'all aware, they are not back in court just yet. But I don't know. I'm assuming I don't think so. Like this right here, this part right here. Wait a minute. Like this part is stupid. This is stupid. Wait a minute. This is when I was so over Chris. It was at the end of his stuff, but I was so over him and what he rehearsed and how he lied and just over. I was
Parties have said it's not hearsay. I'm going to allow you to continue explaining if you choose to do so.
Yes, ma'am. I'd like to continue.
Mr. Melton, I've got just, one, well, I'm not going to call it one question.
question. It might turn into a couple, but just one thing that I wanted to talk to you about, because there's been some testimony about this incident between you and Tara, but there hasn't been any testimony about what that incident was. Can you explain to us, what it is that happened and what this disagreement that y'all had? And I believe you testified it was the only disagreement that you could necessarily recall that was ever serious. What was it?
Just bear with me. There was a time that Tara took care of me. I had gotten an infection. I had cellulitis that had entered my body through my thighs and through my buttocks on a job site late summer. I remember it being hot. I had been shaved. I was on a new job site. I'm sitting on the soil installing plumbing. Well, during that time, evidently bacteria that had been in the soil entered through my clothes, entered my skin, and got me infected. That same day, later that evening, Tara was at my house, and she saw the effects it was having upon my body. And I'd swollen up in between my thighs and my legs, and my skin started turning black. She told me, you need to go to the emergency room. She took me to the emergency room. Once that was taken care of there, I had to come back to my place, and I could not walk or move around for a long period of time, possibly up to, if I can recall, 2 weeks. Okay. During that time, Tara was my caretaker. That's when she was given a key to get in and out, because I could not go up and down the steps without having her come in to take care of me. Well, time goes by. Now I'm at the end of this, and I've healed up and I'm ready to go back to work. So she has stayed over. She stayed behind that morning to show herself out. Once I had gone to work, she had called me and said, we need to talk. And I was like, okay. Well, she said she would meet me back at the house, meet me back at my place. While I was gone, what she had found, I had a TV armoire with VHS tapes. And as embarrassing as it is, and this is something I had since I was 19 from back in college, she found an adult video. It wasn't anything crazy. It was just one video in bright orange, I might add, so it wasn't concealed. It was just there. That hurt her feelings. She felt so disrespected. I was ashamed. I was embarrassed. I can't even quite remember the last time I had even seen it, but I was still in possession of it. She sat down in that argument and she demanded, when did you come in possession of this? And then I further explained that when we were in college, back, I guess I'm 19 at this time, one of the cheerleaders was actually marrying another cheerleader. It was a man and a woman. They had been partners for a while, and they actually were getting married. Well, there was a bachelor party that didn't have anybody, no females show up or anything, but they had this adult video playing on the TV during that crazy little bachelor party guys kind of thing. Well, that's how I obtained it, because I asked the host, I was like, hey man, you mind if I have the tape? I was not in a relationship or anything at the time. I'm ashamed to say that, embarrassed. But when she found that, I felt like I broke her heart. That was not who she was, and I hope it's not a representation really of who I am. I was a young man. She found that tape, and that was the only time I can ever recall that she raised her voice at me. And she demanded that I destroy the tape and throw it in the dumpster by my apartments with her hands on her hips, watching me. And I did. And we agreed, and I talked it out, and I laid everything out for her as she asked, and I was laying all my cards on the table. I was honest with her. She chose to show me grace, and she was understanding, and we made up that same day and in that evening. Okay. But that always stayed in the forefront of my mind as the time that I could have jeopardized our relationship. And I've always shown her respect, and I didn't realize I was showing her disrespect in that fashion at that time, but she made it clear that that was inappropriate and that I should never do that again. And I agreed. And that's the incident that I explained to law enforcement when they asked me, is there ever a time that's what I hear? Is there ever a time that you have jeopardized your relationship? And that's when I tell them that story.
I tell them that story. Yeah, it's definitely a story that you made up, that you rehearsed, and the prosecutors knew, and they knew that you were going to have to give a story about this. That's why the first question when he got back up, he was like, hey, is keeping this thing and all this question in regards to a story or argument that you and Tara got into, but we haven't really got into what that argument was. Why don't you tell us the story? Like, are you for real? Like, now that was a bunch of crap, in my opinion. Like, bunch of crap. Him doing that. I hope that during closings, that they do try to that they do play some of his stuff. Especially like when he said it was rehearsed. Let me check the courtroom. Nope, they are still at break. So let me see here. This guy here. Because believe it or not, the state didn't question Chris that long. Y'all don't know. I feel like I got something sticky in my eye. It's making my world bad over here. That's what I can tell y'all. My nose is running. My eye is watering. No, it's making a whole bad deal.
Mr. Milton, would you like a slim marker or a big marker? record reflect that I am going to give you a black Sharpie, okay? I'd like you to write the very first time that you mentioned during your direct examination in regards to your actions or where you went on January 19, 2001. Do you understand that?
Yes.
May I approach the witness, Your Honor?
May.
Can you please write the first place you went on January 19th on that board there?
And Your Honor, I would ask that if Mr. Cruz is going to ask the witness to engage in whatever this is, that be repositioned to a place where the jury can actually see it.
I can do that. We'll start on page 2.
And we'd like to also be able to see it. I guess, Judge, do you want us to move or do you want him to move it over there?
Chris, I think perhaps moving that back would be best for everyone to take a look at it. Thank you, Mr. Hill.
Sure.
All right, sir. May I proceed?
Sure. Can you write the first place you went and the time that you went to that location? Okay, so I want to make sure I'm correct. You wrote Nash Plumbing 7:30 to 7:45. Okay, so you remember from January 19, 2001, you went to Nash Plumbing between those times. Is that fair to say? Okay, but you could not remember when law enforcement asked you if you knew Ms. Baker was going to be alone in 2006? You can take a seat, Mr. Miller.
Along the way, I'm questioned about certain things, and I pull up my best recollection. Post this, I've been traumatized. I'm grieving. My mind is certain things and certain times. It's hard to pull from. And in those moments, stress also, in times, it's more difficult than others in certain moments to recollect certain things. And sir.
Let me catch up. So it's easier to recollect an alibi than it is to recollect whether or not the girl that you love told you that she was going to be home alone.
For this question, it's argumentative and improper.
Sustained.
Sure. So it's easy to remember where you went on the 19th. Is that correct?
That is correct.
Okay. Mr. Melton, so after you left Nash Plumbing, where did you go?
After I left Nash Plumbing, I went to the bank.
Okay. Can you write the time that you arrived at the bank on the board? You can just put bank and then you can put the time.
Gonna work them like the jury. He getting up and down, Mr. Milton. I'm about to work him.
Okay. Sure.
That too big suit off. Who gave her that suit?
So just ask you. So you can remember that you went to Nash Plumbing, and then after that, you can remember that you went to the bank from January 19, 2001.
That's correct.
But you cannot remember from January 18th whether or not Ms. Baker told you she was going to be alone?
At that time, it could depend on when the question's asked. It's not, if it's in a stressful moment, I'm going through things and trying to pull from times prior to this, when I'm not trying to, how should I say, lock in on certain things previous to this. It is difficult.
Would you agree?
Previous to to her death. Go ahead.
I didn't hear you. Say that one more time.
I should say, it's like certain days, if somebody asks you what you have for breakfast, I couldn't tell you. But if I'm concentrating on after certain times, yes, I can on certain things. But it's hard to describe.
So I'll switch gears because I do want to talk about a difficult subject with you. You mentioned that you were told that your DNA was in Miss Baker's anus. Is that right?
Yes, there was a point in time. I know.
And we've.
You ready now? SD, I dropped a link in the chat if that's what if you ready to come up here now. It's up to you. You can definitely come up here and explain to us why you think Chris is guilty. I'll let the video play until you get up here. They are still out. They have not got back. Oh, here she go. Oh, she must be really on it today. She ready to get up here real quick. You ready? I don't see your photo. You must be, you coming in off camera. I'm adding SD to the stage. Can you hear me?
I can hear you. Can you hear me?
Yeah, I can hear you. Sorry.
Okay.
I don't know if I got allergies or what I got, but I got a runny nose and an eye that won't quit. Too legit. Good morning. Good morning. I'm gonna mute up because I got the sniffle. I got the sniffle. Go ahead and explain to everybody since you.
Okay. He keeps claiming that he hadn't seen her for 6 days. And I think at one point he even said 10 days. But the thing is his DNA would not be on her body after that many days. She would have brushed her teeth. She would have showered for school. There's no way that his DNA just magically appeared after all that time unless he was there and he did the crime. I don't know. I can't even explain why Mr. Faust's DNA was there, but it wasn't in the areas where she was raped, you know? It was Mr. Melton that his DNA was like in the area where she was raped. And I mean, there's just no possible way, you know, like that it's been 6 days and it lasted there that long. It would have drained out completely and she would have showered it off. So he cannot explain why his DNA was there. And I think he's guilty of the crime. I think he did it. Okay. And that's all I have to say about that.
Yeah, I agree. I think that the biggest thing and the problem with all of this is that, you know, at first it was 10 days. He hadn't seen her. And then when the DNA results came back 23 years later and they say, well, no, you had to see her because your DNA pushed you there. And we have to cover this time frame window. They covered that time frame. What I don't understand in regards to all of this, why are they going after Mr. Faust? Why can't it be Chris? And that's my problem with all of this.
I think they went after Mr. Faust. To be honest, I think they're racist. I really do. And you know what? Georgia is known for that. Well, I mean, they have a bad history.
I heard in this area it's really progressive. So I don't know if this area was really that. Courtroom Crawford. I don't know if they were really like that down there in this area. From my understanding, I heard that they were not. I just don't understand why, even if we're talking about back then, why are we still 23 years later continue to go away from Chris? Like, does he have family there? What does he have going on there that we, that why would they want to do this? And that would be my underlying reason. Like the
Yeah.
why would they want to pin it on Mr. Faust? Like, did he do something to somebody? And that, like the underlying reason, because there has to be a reason. Because I just really don't think that they just out there to get him because they're trying to.
Well, they charged him during the Trump era, and racism has been alive and well. And I'm not trying to get political. I'm just saying there's a lot of racists popping their heads up these days and showing their colors. And Mr. Melton's aunt was the bank teller, right? And so his parents told him, they're coming after you. And I think he told them, well, I was at the bank. I was this and that, So they probably called his aunt, and I'm willing to bet she forged that receipt.
Oh, you think so? The aunt was the bank. The aunt was the bank teller.
I think she was. Didn't you say that was his aunt?
Oh, don't you better not go by nothing I say. I be just seeing stuff.
Oh. Because as soon as you said that, I was like, she forged that, So
no,
maybe
that's
that
why
wasn't
you was talking shit.
Okay. So I'm just curious, like, where did his parents work at the time? Like all that stuff. Like, who does he know in law enforcement? I really want to know all these questions. And I hope they researched Mr. Melton and got some clues as to why the state didn't go after him. And I can't wait for the defense to put on their case.
Yeah, depending on how limited this case is going to be, right? Because she's stopping a lot of this stuff. And I guess they don't want to confuse the jury. I just don't know. They got to do something with this DNA. And I'm not saying that the state has explained it totally, but I definitely think that the defense has to do something to make something plausible of why his DNA got on her. They better say that they, planted it there. They got to do something more than what they're doing now.
Yeah, well, I think they do have to explain how Mr. Faust's DNA got there. And I kind of think because he didn't admit to knowing her, that, he might have screwed up, because it looks like they had a one-night stand. Like, she went to the Mexicali Grill and they hooked up. And I don't know if Chris knew about it, but he was just really pissed that she was breaking up with him. Her friends said she didn't want to see him. She went to a party without him. She was distancing herself completely. And he had to have known that she was distancing herself. And he kept calling her his true love.
Yeah.
So,
okay.
It might have really angered him if he knew. But even if he didn't know, she was getting out of the relationship. And obviously, by his testimony, he wasn't accepting that.
Yeah. So Derek put in the chat, he said they did go after Chris, but his alibi panned out for him. And see, that's my only problem with them, is that even though his alibi may have panned out at that point in time, when you coming back and you are, when you come back and 25 years later, how can I can't tell you what I did 25 years later.
Yeah. But they didn't even check his alibi, did they?
I don't know what alibi Mr. Faust could have had at that time. Like at 20 years, because remember, they didn't start investigating him until 25 years later.
Yeah, I'm sorry. I meant Mr. Melton's alibi didn't check out because they never checked it.
Yeah, now his alibi was not great because of the fact that they had them hoes in it, because they talking about, I don't know what he was doing from 7 to 9. That's the big problem,
Yeah, he didn't even mention that his friend brought Chick-fil-A. Like, and his memory is so good, apparently, when the state's crossing him.
Oh, we all know that was rehearsed. So,
yeah,
that part we know was rehearsed, but they.
Yeah, and he rehearsed it wrong, in my opinion.
Shout out to Susie. Thank you so much for the super chat. You say get some rest. I don't know. I think I'm gonna go rinse out my eye once we get into court.
Yeah, that's a good idea. I was going to suggest rinsing your eye out in case you have some particulates in there.
Yeah, because it is like, it's like constantly watering, and I'm like, it's making everything run. It's like TMI.
No, it's fine. But I've never felt so passionate about someone not being charged and the wrong person being charged. Except for an Alicia Andrews. I don't think she should have been charged at all, but I just feel so passionate that they're doing this all wrong. And I would love to see justice in this case.
Yeah, well, I think the one good thing is that with this case, and these are the cases that I like to be into because there's reasonable doubt. Like some cases we go into and it's just like, oh, they are just guilty. They just guilty. No matter, we know they guilty, right? Even though I be up here, playing games and letting y'all know, like, no, we are supposed to keep clear mind. But at the end of the day, we know that they're gonna be most likely guilty. So, but in this case, I really, really, really think that there is really where he can be not guilty. And not even that he not guilty, guys. I think more or less my position is that I don't think the state can prove their case.
Yeah. And I think, like John said, Truck Customs timeline of when Chris came and Chris's timeline of when he came to Truck Customs don't match up. And so I think the whiteboard thing is genius. It's easy to just say, here's the testimony everyone gave. And you can see that this doesn't match that, And I just love what he's doing with the whiteboard.
Yeah.
It's gonna really help.
Yeah, it's gonna go back to the jury room with them. But they are back in court, so I am gonna take us back in there. I thank you so much, SD. When we go on any of our breaks, whenever you want to come up, anybody for that matter of fact, if you ever want to come up here, you are more than welcome to come up. Sometimes the chat is moving fast and people just want to speak, they speak.
Yeah. Well, thank you, Sweet Pea, for hearing me.
Oh, absolutely. Mi casa is su casa. All right, let's go back and live in the courtroom. I'm going to rinse my eye and we will go from there.
Let's do it.
All righty.
I understand you received.
Oh, that'd be great. Thank you. All right. Let's go on the record. Mr. Cruz, have you had enough time to have the conversations you said you needed to?
I have, Your Honor.
Okay, very good. Are you ready to proceed?
We're going to close the evidence, Your Honor.
Okay, so you're going to rest.
Yes, ma'am.
All right.
Not putting on the case. They're not putting on the case. They're not putting on the case. Oh my goodness. Somebody call 911.
I want to talk about timing, some timing issues.
Holy shit.
We can sort of have more of a free-flowing conversation.
What the fuck? What did they just do? They not putting on a case.
Welcome back, ladies and gentlemen. Appreciate you all again being here on time. We are ready to resume State of Georgia versus Edrick Faust. SU 24 CR 0547 is state ready. State ready?
Ready, Your Honor.
Defense ready to proceed?
Yes, ma'am.
All right, ladies and gentlemen, the state has rested. Mr. Cruz?
Defense rests.
The defense rests as well. Ladies and gentlemen, that means the evidence in this case is closed. So now this is what we are going to do. And I want to tell you sort of how the process works. The evidence is closed in this case. And the next step for all of you is to hear closing arguments. There's something that has to happen before that. and it's called a charge conference. And it is a conference, it's a meeting with the court and all the attorneys about what law is to be given to the jury in its charge. That is something that, of course, has to be done outside your presence, as we have done many things outside your presence during the course of this trial, including this morning, which is why I had you come in later, because we were doing things outside your presence, and I just didn't want you sitting in the jury room for, when you could be at home or doing other things. But this charge conference, of course, must happen outside your presence, and it's going to take us a while to do it. I'm going to give you a very long lunch break. I'm going to give you a lunch break until 2:30 this afternoon. And so I'm going to ask you to return back here at 2:30. I know one of the jurors has an appointment. Don't rush to come back. If you're a little bit late, it's fine. We will not start without all of you being present, so don't worry. But if you'll come back at 2:30, we're going to begin closing arguments at that time. The same instructions I have given all of you apply, right? Don't discuss the case with anyone, of course. Don't do any research independently or on the computer. Please don't go to any of the locations you may have heard about. Enjoy your lunch. It'll be a long one, but we'll see you back here at 2:30. Thank you very much.
Oh gosh, it's 11 o'clock there, and oh my goodness. So I wonder, are they gonna let us see the charge conference? We'll wait around and see. Oh my gosh, I can't believe they didn't put on any evidence. I was not expecting that today. Yeah, we'll go into that one at 11:30. Well, 9:30. I'll open up another room for that. But I wonder if they're gonna show us.
All right, you all may be seated. Thank you.
Okay.
All right, we're going to be in recess till Ms. Ellis is finished with compiling the charges from the state and the defense, and then we'll be back on the record and we'll have our conference. All right, thank you. Court is adjourned for the moment.
Oh, okay. So they adjourn until they get some stuff in. So there's that. So I guess we won't know. I guess I'll keep this up. I don't know if we'll be able to. What? I don't know what happened. I can't believe he did. I don't know why they didn't put on a case. Do y'all think that they were just trying to make the state think that they were going to put on a case and didn't decide to put on a case, or I don't know. I don't know how to call that one. You think that they didn't do their case because they couldn't call their witness? What about this lady that was all out of country and stuff? And what about the DNA person? No, we need somebody in regards to the DNA to come in and combat that. Those articles do not do it. I'm up here trying to woo-saw about this. The hell? Oh my goodness. Okay. I mean, I'm okay, but I'm not okay, and I'm probably gonna need my hand held during this doggone sentencing that we going into with Twerk and Tina. Yeah, I think that yeah, John, I get that, but I wanted them to have somebody on the stand to say that. I mean, besides her, and I was wondering if they were gonna use those articles to try to alleviate having to have an expert, and I guess that's exactly what they did. Okay. So I don't know how many, if any of y'all watched the Brandon Banfield trial with Twerk and Tina. We do also have our day 2 of our wife dumped in the tank trial. Since our Twerk and Tina is the one that's going to be starting up, we will start with that one. Let me get that up for us. I'm going to keep this up so that way we don't miss a minute of any of the courtroom action. The au pair sentencing for Juliana does not start until 9:30. And my judge, she do like to be on time, so. Oh, thanks for the update, Derek. Thank you. Yeah, I want to see what that verdict gonna be. Let's see. So I guess in this, I think that what we will do here is I will close this room. We will open our other room with our verdict. Not our verdict, our sentencing for Twerk and Tina. Here is the link. If you click on the link, it will take you directly into the room where we will watch the sentencing for Twerk and Tina, aka the all pair, aka Juliana some Perez something. Will she get the max penalty, or would the judge just let her go home? Right, Eleanor. I totally agree with that part. And I will keep an eye out on this for us, just in case anything comes in. They said 2:30, so 2:30 is 12:30. So they're talking about 3.5 hours. Yeah, you can go over there to that link. You can use that link now to go over there. And I will switch us back over here when they start closing arguments today. In the meantime, in between time, we will go ahead and get ready to watch our sentencing. Let's see here. And yeah, guys, and I'll put out another alert for anybody once I'm gonna set up another feed for this one. I wasn't planning on doing that today. I didn't know they were gonna do me like that. So I'll set up another link so y'all can get another notification for those that are not going to go watch the sentencing for the all-pair trial. As soon as we get started back with this one, I'll bring us back over here. Yeah, I'm just so scared that I know they said court is adjourned, but I wonder if she's gonna come back and let us see the charge conference. So I'm trying to see if I should leave this open because some people may want to see the charge conference. I'm gonna leave this one open for now, and we'll see if they do the charge conference over here for Edrick Faust, because I would like to see the charge conference. So let's do that, and we'll just replay some of his testimony. But if you want to go into the other room, you're more than welcome to go into the other room too.
Ways, Mr. Miller.
I don't understand the
Previously stated that Miss Baker, not Miss Baker, I'm sorry, Miss Bigham and Jeremy Howell told you that your DNA was in her anus. Can we agree on that? Is that fair to say?
Maybe I'm mistaken on how I found that information out. Maybe
I'm going to object to lack of personal knowledge. Mr. Cruz is asking this witness about information relayed to him as hearsay by other witnesses who had the actual information. So I think that's both lack of personal knowledge as well as calling for hearsay.
Right. Any response to the objection, Mr. Cruz?
Sure. Mr. Melton stated that he was aware that his DNA was found in Ms. Baker's anus. He stated that Ms. Bigham and Jeremy Howell were the individuals that told him. We're fleshing out his knowledge in regards to what he's aware of, Your Honor.
I think as to the form of the question, I'm going to sustain the objection. You may rephrase if you choose to do so.
Yes, ma'am. Thank you. Thank you, Your Honor. But there should be no reason that your DNA should be in Ms. Baker's anus. Would you agree?
I mean, other than if we have had sex and it has transferred from there and say drained down to that area. But
that is interesting that you say drain, because did you know that's the exact same thing the state is arguing in this case?
I mean, it makes sense though.
So your DNA is in her anus because it drained down in her anus. Is that your position?
I would say that would.
Again, Your Honor, lack of personal knowledge, lack of foundation. There's been no foundation laid that Mr. Melton's aware of these things. That would all be through GBI crime lab witnesses who do have personal knowledge and scientific information. And so there's no foundation for these questions, and he's asking for things that are outside of Mr. Melton's personal knowledge. He's asking about things.
I would object to a speaking objection, Your Honor, and just ask the state to state the ground.
Okay, I'm going to overrule that objection. He was just explaining his objection. I'm going to respond in the same way as the last objection. I'm going to sustain the objection as to the form of the question, allow you to rephrase if you choose to do so.
Yes, ma'am. Thank you. Thank you, Your Honor. Would you agree that in order for your DNA to drain into Ms. Baker's anus, you would have to have sex with her? Can we agree on that point?
Agree.
Okay. Did you have sex with Ms. Baker the day of her death?
No, sir.
The last time you saw Ms. Baker, was it 6 days before, 10 days before?
From the beginning, I said I saw her the weekend prior.
From the beginning, you've said that?
Yes, sir.
That you've seen her the weekend, and that has always been what you said?
There was a time that I was confused, and it was 20 plus years later. And then I made a statement that I felt like maybe it was 10 days prior. And I was confused at that point because I have always said from even meeting with the detectives from the beginning that we were together that weekend. And then time had gone by and I had even spoke out publicly for the first time.
Mr. Melton, to my question, is that a yes or a no?
He's in the middle of providing us an answer. Again, the witness has a right to answer Mr. Cruz's questions in the manner that he believes the answer should be given.
It's non-responsive, Your Honor. And I would ask the state to stop the speaking objections because they are coaching the witness in the middle of his testimony.
Okay, I'm going to overrule that objection and I'm going to sustain the state's objection. This witness is allowed to respond to your question. And if he's in the middle of responding, no one can interrupt. You may continue if you choose to do so.
Well, time had gone by. And then I had spoken publicly. At this point, I have stated over and over again that we were together the weekend before. And then there was a point in time that Tara's mother had stated that she was at her house.
I'm going to object to hearsay.
I am going to sustain that objection.
Your Honor,
Yes.
I don't want to send the jury out, but I would like to approach to understand the parameters of which I could.
Oh, he can't win. He can't win. They letting the state do everything that they want to do, how they want to do it, when they want to do it. He is cooked. He is cooked. It ain't gonna happen. He's not gonna be able to question this witness. This is absolutely terrible. I can't believe this judge. Like, she gonna tell him that his thing is sustained and that this guy can explain, but then he gets to explain it too much, and the state like, whoa, you talking too much. So now they objecting because they just letting him do all this talking. Oh, she's not gonna let him question him. Oh goodness, I am about to be hot over here. Like, I'm sick of her. I'm so sick of her. She gonna be right there with Alicia Andrews, judge, where they gonna overrule it, kick her off the case or something like that if this man gets convicted, because she is not allowing questioning the way it should be handled. Oh, they get to do whatever they want to do because he not babying him and walking him through this stuff. Oh no, everything is wrong. And he don't have the answers. And now he got to do all this explaining. Whatever happened to...
No, sir. I think it was in my old bedroom.
Y'all remember what that means? Yeah, there you go. It just makes sense for it to drip. I don't agree with that, because if y'all had whatever kind of romantic stuff 3 days later, now I can see up and them finding like DNA, but down, like somebody not wiping good enough. Like 3 days, that should be gone. I don't get that part.
Your current residence, I won't say your address, but your current residence is the same residence that your parents stayed in 2001. Is that correct?
That's correct.
And at that time, you stayed in the basement. Is that correct?
At that time, I would have been on the second story.
Forgive me.
Bedroom.
I asked that question wrong. The week before Tara's death, you went to your parents' home. Is that correct?
That's correct.
During that time, you stayed in the basement. Is that right?
No, sir. I think it was in my old bedroom in the second story.
Court's indulgence, Your Honor.
I feel like I remember The Wiz. I feel like he like the Scarecrow with Michael Jackson on the thing, like, you can't win. That's what I was thinking of. Where the little birds was going around him. That's like, you can't win, child. Yeah, the state didn't hear his interview.
I was working there and driving back and forth. Well, my parents, that we had a finished basement. So then that's where I was keeping in well, pretty much Jersey.
I guess while they're getting everything queued up, before I forget, I want to say shout out to Dr. Rachel for the gifted membership. Keep it green this morning. We have a moment of silence. I don't want to forget. So thank you.
There and driving back and forth. Well, my parents, that we had a finished basement. So then that's where I was keeping in well, pretty much Jersey.
Okay, did you hear that? I was driving back and forth. We pretty much had a huge basement. That's where I was keeping, and then I cut the audio off.
I hear that.
So you were staying in the basement, is that correct?
I would stay in, there's times I stay in both. We had finished basement and had the bedroom upstairs.
Okay.
And the furnished basement was set up as a place to stay, a place to hang out for whoever.
Objection,
and also had my
Overruled.
So
You may continue with your.
the finished basement would have like a couch, sofa, TV, things, in my old bedroom upstairs also had a bed and so forth. And I would stay and, hang out in one, stay in the other, depending on who was there at the time, if we had visitors or whatnot. So I would stay in the basement if nobody else was using it.
narrative.
I'm going to overrule the objection. You may continue.
So with that being said, I feel like kind of both are true. I had my old bedroom and they had a furnished basement.
I'd like to show you what's been marked as Defense Exhibit 33 and Defense Exhibit 34. Let the record reflect that I'm showing Mr. Melton what has been marked as Defense Exhibit 33 and Defense Exhibit 34. And Mr. Melton, you recognize Defense Exhibit 33 and Defense Exhibit 34 as photographs of your house. Is that correct?
That's correct.
Okay, and I believe Defense Exhibit 33 is the side of your house, and Defense Exhibit 34 is the back side of your house. Is that right?
That's correct.
Your Honor, I would move to, have those photographs been altered in any way?
No.
And that's a fair and accurate depiction of your home. Is that correct?
Correct.
Your Honor, I would move to admit Defense Exhibit 33 and Defense Exhibit 34 into evidence.
No objection.
They are admitted.
Now, Mr. Melton, you would agree there's a reason why you would say that you were staying in the second story of the house, correct?
As far as
There's a backdoor exit on the basement. I believe that's Defense Exhibit 34, if I'm not mistaken. Is that right?
there's a basement exit. Yes, sir.
And there's also a side exit from the basement, which was Defense Exhibit 33. Is that correct?
There's one exit. There's a door on the backside that goes into like a dead space that's more for access.
So Defense Exhibit 34, the backside is a door to enter and exit the basement where you don't have to go in the house. Is that right?
The side door would be. The back door is not.
But either way, there's an exit there's an exit from the basement and the entrance into the basement. Is that right?
That's correct.
Now, you recall your parents talking to law enforcement?
They did.
And they were one of your alibi witnesses. Is that right? Were you aware of that?
I would say yes. They knew I was there.
And you're their only child?
I am.
And by the time law enforcement spoke with him, you had been staying with him for 4 months. Is that correct?
I had started staying with him after this incident. Yes. So, yes.
After Tara's passing?
That's correct.
So if any other witness said you moved home months before, that would be untrue.
That's correct.
I want to talk to you about Miss Baker a little bit, okay? We'll switch gears and come back to some of this stuff. Would it be fair to describe Miss Baker as super friendly?
That'd be a fair statement.
You would also describe her as down to earth?
Correct.
She did not have any racial biases?
No, sir.
And although she was a law student, you would agree that she was not pretentious?
I mean, no, sir. Not unless it's for little specialty things like her collections of things, but no.
Now, is it fair to describe Miss Baker as a casual dresser, shorts, hiking boots, sweat top type of girl?
Yes, sir.
She was more of a flats over heels kind of girl. Is that fair to say?
Fair to say.
Okay. And she had more of on her day-to-day appearance, she had more of a casual appearance that did not include daily makeup. Is that right?
I would say, light makeup, if any.
I'd like to show you what would be marked as Defense Exhibit 35. Your Honor, I'd like to approach the witness to show him Defense Exhibit 35. Do you recognize the photo of Miss Baker?
It's Miss Baker. Miss Tara.
And is that how Miss Baker, makeup-wise, hair-wise, is that how she carried herself mostly on a daily basis?
I'll say yes.
And that's the fair, accurate depiction of Miss Baker as you would remember her.
I'll say yes, sir.
Your Honor, I would move to admit Defense Exhibit 35 into evidence.
Any objection?
No objection, Judge.
It is admitted.
Thank you, Your Honor. Now I'd like to ask you about the times that you visited Miss Baker's home in Deer Park. Is that okay?
Okay.
All right. Is it fair to say that you've probably visited Deer Park more times than you could count?
She wasn't there a terribly long time, but I would say, yeah. We've been there many times.
Okay. And during the times that you visit Miss Baker's apartment, you'd see normal foot traffic. Is that fair to say?
That's fair to say.
And that foot traffic was due to a Walmart being on the opposite side of the neighborhood. Is that correct?
I'd say there's a Walmart. Yes, sir. And
now, the majority of that foot traffic, it was African Americans walking. Is that fair to say?
It's fair to say.
And those African Americans were typically in the late teenage, young adult range. Is that correct?
I would say it would vary, but I would say young teenagers, I would say.
Now, in regards to Miss Baker's passing, on January 19th, you testified that you went to the scene of Miss Baker's death.
That's correct.
And while at the crime scene, you were asked to identify Miss Baker.
That's correct.
Okay, and you were shown a single photo of Miss Baker. Is that right?
That's correct.
And I'll let the record reflect that I'm showing the state what has been marked as defense exhibit 36. Let the record reflect that I'm showing Mr. Melton what has been marked as defense exhibit 36. You recognize that photo?
I believe it's the photo I saw.
This was the photo that you were shown to ask to identify Ms. Baker?
No,
This was not the photo.
I don't believe that was the photo.
Can you describe the photo that you were shown to identify Ms. Baker?
I believe that her head was turned slightly, and there's coverage that
Mr. Melton, you're just shown a photograph of Ms. Baker's deceased, and you have not shed a tear.
Come on now.
It's coming. Give me some time.
I need a moment.
Sure.
I'm getting them together. I'm hyperventilating right now. This is the way I react when I'm up under extreme stress, sir. It's coming. Yeah, put your head up on your hip.
Hold together. Okay.
He about to cry now.
So let's switch gears while we're here. You testified on direct examination that you became so upset that you punched the wall in your apartment. Is that correct?
When I unleashed the emotions, yes.
Okay. And when you unleashed the emotions, you became extremely angry. Is that correct?
I was upset. Yes, that would. I was upset at the situation.
And the way you chose to release your emotions through violence. Would you agree?
Towards that wall.
But you told the jury that the injuries to your hands came from punching the wall. Is that right?
My injuries came from punching the wall.
Okay. And we've already agreed. Well, you testified that the wall was sheetrock. Is that correct?
Correct.
I'd like to show you what would be marked as Defense Exhibit 37. Defense Exhibit 38. Defense Exhibit 39. And Defense Exhibit 40. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 37 through Defense Exhibit 40.
Okay, I put it on Do Not Disturb. Look at him. He take a deep breath in, deep breath out.
Your Honor, let the record reflect that I'm showing Mr. Melton what has been marked as Defense Exhibit 38 through Defense Exhibit 40.
He over here woosah.
I'm sorry, 37 through 40. Please forgive me. Is it okay if I approach you, Mr. Melton?
Yes, yes, sir.
Deep breath in, breath out. Deep breath in, deep.
Please take a moment and take a look at Defense Exhibit 37 through Defense Exhibit 40. You recognize Defense Exhibit 37 through Defense Exhibit 40 as the wall that you punched. Is that correct?
I would say yes.
Okay. Is that a fair and accurate depiction of how that wall looked after you punched it?
say from what I could recollect.
Sure. Has that photograph been altered in any way?
I'm not sure. I wouldn't.
But you have no reason to believe that photograph has been altered in any way. Is that correct?
I have no reason to believe.
Your Honor, I would ask to admit Defense Exhibit 37 through Defense Exhibit 40 into evidence.
Any objection?
No objection.
They are admitted.
Thank you, Your Honor. I would ask to publish to the jury.
Granted.
The state did not tell me it was gonna be like this. He closing his eyes. He like literally shaking his head. They didn't tell me it was gonna be like this.
Let's talk about the injuries to your hands, Mr. Melton.
Yes, sir.
Of course, indulgence. And the photographs of your hands have already been admitted through, as Defense Exhibit 29. Elected. And Your Honor, I just asked to republish the photographs of the hands to the jury.
Granted.
Of course, indulgence, Your Honor. I need one of these photographs. Mr. Milton, I am going to show you one of the photos from Defense Exhibit 29, and we're going to talk about some of these injuries. All right, can you see your hands on the screen, Mr. Milton?
Yes, sir.
Okay, and you would agree, for the purposes of the record, I am making a fist. Mr. Melton, you would agree that a fist looks like this, is that correct?
Yes, sir.
Okay, can you make a fist and show the jury what your fist looks like? Okay, excellent. I want to talk about this injury here on the side of your thumb. Can you explain how you got that injury from punching drywall?
My hands are from work.
Are they?
I mean, no, I'm saying my hands from work are naturally have nicks and such on them, but that very well could have occurred. I mean, from punching through a wall, there's also things inside the wall. There's siding on the wall that has, once you go through, there's nails that may have been there. But at that point, I mean, I have little nicks and cuts just from my profession.
But Mr. Milton, isn't it fair to say as a plumber, you wear gloves?
No, sir.
You never wear gloves?
I wear gloves, but not 100% of the time. No, sir.
Well, I showed you Defense Exhibit 37 through Defense Exhibit 40. There's a pair of gloves hanging on your wall, Mr. Milton.
Hanging on my wall.
But you don't use them.
When you're working with your hands, you work quickly also. And you don't have time to always have gloves on. And at that point in time, I'm not working with raw sewage or anything. This is new materials. So with that being said, you not worried about bacteria or anything infecting your hands. You just work through it.
So today, on February 9th, 2026, you remember exactly how you were working on January 19, 2001.
It's easily to assess because I worked it for so long.
Sure. But you don't remember whether or not Ms. Baker told you she was going to be home alone the day before her death.
You know, in moments under stress, I can't recall everything.
So let me ask you about this injury here. So did this come from the wall or did that come from work?
Is that an injury?
Right here.
I don't know if I...
Or how about this injury here, Mr. Melton? How would you get this injury on the top of your hand going in this direction from punching sheetrock?
That even appears. Oh yes, when you punch through walls, you got to pull your hand back. I'm punching into a wall, pulling my hand back, punching through a wall. And even at work, I have nicks, cuts, and even burns from soldering pipes and hot materials. I can't tell if that's an injury from hitting something or an injury from work, and it may look like that even looks like it could be even a slight solder. It's hard to say. I mean, it's hard for me to assess that.
But this is the first time in 25 years that you've ever made the statement that these injuries were from work. Would you agree?
I've never been asked the question as far as if they're from.
And just to make sure we're on
That I can recall.
Just to make sure we're on the same page. Your exact statement was to law enforcement is the injuries. Matter of fact, we don't even have to go to law enforcement. Your exact statement in the court before these jurors was that these injuries came from punching the wall in your apartment. Do you recall making that statement?
Was this prior to being shown pictures?
Mr. Melton, do you recall making that statement?
Yes, I had injuries from my hands from hitting the wall. That's what I recall.
But when I asked you about the injuries, you are now saying that they're from plumbing and hitting the wall. Is that right?
Well, I have, when you're pointing out specific things, like I do have from plumbing, you're going to have nicks and cuts or whatnot from that. Just.
My question is, during my examination of you, this is your first time saying that these injuries are from plumbing. That's a yes or no question, if you can.
Since you just asked that question, I guess I would have to say yes.
And once the jurors finish looking at the photos, we'll go over some other photos as well. Now, on the day of Tyra's death, you voluntarily went to the Athens Clarke County Police Department.
That's correct.
Okay. And I believe the state asked you a couple of times, did you hire a lawyer or did you refuse to speak to him? When you agree as the boyfriend, if you refuse to speak to him, you will look even more guilty?
Restate the question.
Sure. The state asked you on direct examination multiple times about whether or not you got a lawyer or whether or not you refused to talk to him. Do you recall being asked that question?
Yes.
Okay. When you agree as Ms. Baker's boyfriend, you will look more suspicious if you refuse to talk to law enforcement.
If I refused.
Okay.
Yeah, okay.
So we agree on that. Is that right?
Of course. I mean, I'm always wanting to be cooperative.
Sure. But that was a yes to my question, right?
Yes.
Okay. You would also agree you will look more suspicious if you refuse to give blood. Is that correct?
Correct.
Okay. You will look more suspicious if you refuse to give hair. Is that right?
Correct.
You will look suspicious if you refuse to talk to him. Is that correct?
Correct.
Now, you conducted an interview with Officer Bill Ricketts on the 19th. Do you recall that interview?
I believe so.
And you state you believe so. Are you certain that you remember conducting?
Yes, I remember an interview on the 19th.
And your father was present with you during that interview. Is that correct?
Yes.
Okay. And he sat with you for the entire interview?
Yes.
Okay. And during that interview is when you told law enforcement that you were at your parents' home at 7:15 on January 19th. Is that correct?
Yes.
Do you recall during the interview being asked how would you describe you and Ms. Baker's relationship?
Yes.
And your response was that she was your borderline fiance.
I recollect.
Okay. And you advised him that you and Ms. Baker were very serious at the time of her death.
Yes.
I believe you established with the state that the truck you used for work at the time of Ms. Baker's death was your own work truck, the truck you purchased. Is that right?
Correct.
Now let's talk about Josh McCourty. The state asked you about your relationship with Josh, and you stated that he was just a coworker that you met at McCart Plumbing. Is that correct?
Correct.
Okay. Josh stays less than a mile away from your home. Is that correct?
Correct.
Josh knew where you lived. Is that right?
Yes, he worked for me.
Okay. You knew where he lived?
Once we became coworkers.
And you two attended the same high school?
That I'm unsure of.
You're unsure if you attended the same high school with someone you stated was your employee, Mr. Melton?
That's correct.
But to law enforcement, you only identified Josh McCourty as somebody that you work with. Is that right?
Correct.
Now, you stated on direct examination that while at Nash Plumbing, you loaded up supplies. Is that fair to say?
Correct.
Okay. But at no time did you provide law enforcement with any documents related to your employment at Nash Plumbing. Is that right?
That's correct.
So in regards to your alibi that you were at Nash Plumbing at 7:30 through 7:45, we just have to take your word for it. Is that correct?
I would say so at that point.
And law enforcement did, in fact, just take your word for it. Is that right?
I'm not sure. I would say to my knowledge.
Sure. Now, you stated after leaving, today you stated after leaving Nash Plumbing, you went to the bank.
Correct.
And did you go over that with the state when you all met?
I knew when I had gone to the bank, but yes.
Okay. And you all discussed your timeline before you came to testify here today?
I had gone over it, a refresher.
However, on January 19th, 2001, you told law enforcement after leaving Nash Plumbing, you went to Truck Customs. Is that right?
I'm sorry, I may have not heard you all the way. Say it again.
Sure. On January 19th, 2001, when law enforcement asked you what were you doing that day, you told law enforcement that after leaving Nash Plumbing, you went to Truck Customs.
On the 19th, yes, I did say that.
And you advised law enforcement that you arrived at Truck Customs around 9:30 or maybe earlier. Is that right?
Not earlier, probably 9:30ish to 10.
Mr. Melton, this isn't the first time that you've had the opportunity to discuss your whereabouts on January 19, 2001. Is that correct?
I have been questioned in the past,
okay,
several times.
And you told do you recall making the statement, Truck Customs spelled with the K, TRUK, KUSTOM, and you were asked, okay, and do you know about what time it was? You made the statement, first time was about early 9:30, maybe earlier. Do you recall making that statement?
It seems fair.
So at some point you leave Truck Customs, is that correct?
That's correct.
And I'm sorry, Mr. Melton, do you still have that marker I gave you? All right, perfect. Can you write Truck Customs on that under the bank? And the time that you were at Truck Customs? All right, and you can say right there, Mr. Melton, if you're comfortable, you can write the time next to Truck Customs. Okay, so now it's not 9:30, it is 10 o'clock. Okay, let's do 9:30 through 10, just to make sure that's accurate for the jury.
And Judge, I would ask that if there were going to be questions asked, that the witness be allowed to return to the witness stand so he can speak into the microphone.
I think that makes sense, so everyone can hear, including Ms. Satterfield. So you may have a seat and answer any questions in front of the microphone. Go ahead.
So at some point you would agree that you leave Truck Customs. Is that fair?
That's correct.
Okay. And when you leave Truck Customs, you go to Grayson, Georgia, correct?
Correct. I go to Grayson.
Now, and you can write Grayson on the board for us, please. All right. So do you recall speaking with Detective Ricketts 2 days later on January 21st, 2001?
Yes.
And would you have any reason to disagree that January 21st, 2001 was a Sunday?
No.
During your second interview, you advised Detective Ricketts that you stopped by the bank. Is that correct?
Yes. Then I had failed to mention that I went by the bank that morning. Yes.
And you stated that you were in the bank for a total of 35 minutes. Is that right?
Sounds about right.
Okay. Next to bank, can you put 35 MIN and circle it? Just you put it there. That's fine. Now, during your second interview, do you recall Detective Ricketts coming to you and telling you that he went to speak with someone at Truck Customs?
Yes.
Okay. And in response, before he could tell you what he learned, you would agree that you changed your answer about the time that you went to Truck Customs. Is that correct?
I'm not sure. Not.
Do you recall making a statement? It's like before 12. I mean, it was probably 10:30, 11:30. Do you recall making that statement?
I don't recall the statements, but.
So guys, there is movement in the courtroom. It does look like they are going to let us stop. Hey Cindy, how you doing? So I am going to put us live into court and let's see what they're going to be showing us.
So, what I'd like, where's Mr. Yamacho? You're handling it. Okay, very good. Then we'll continue. Yes. Okay, I will. Yeah. Okay, so Mr. Cruz and Mr. Hill, I don't know if Mr. Bolden has been with us in a charge conference or not, but Mr. Bolden as well. I just can't remember. What I ask you all to do is just go page by page. So what we'll do is, and I'm going to pull out the indictment and go through page one by myself. What Ms. Ellis has done, of course, is consolidate everybody's charges. And it will, of course, eventually be a document that doesn't have the titles of the charges. Obviously, it'll read like just a regular document, but for our purposes, the titles will be in there. So if you all take a look at page one, I'm going to look through the indictment and make sure it mimics the indictment exactly. But if you see any, this is the time, the first couple of pages to see if there are any typos. That's, just make sure we follow. And if there's a typo in the indictment, it goes into the charges as the indictment reads. We don't obviously correct anything. I don't know if there is. I'm just saying that's how we do it. So if you'll take a look at page one and let me know if there are any objections to page one. All right.
No objections to page one from the defense.
All right. Very good. Let's do the same, obviously, with page two. You can certainly go on to page 3 and go through the indictment part of it. And just let me know what you, but I'll wait to, of course, hear from both sides.
There is what appears to be a typo on page 3.
Okay. Well, let me hear from this defense about page 2, and then we'll go to page 3. No, I mean, you can continue looking. I want to go in order in terms of any objections. So I'll wait to hear from Mr. Cruz. There's one. Okay. Okay. Got it. All right. Thank you. If you all go to page 3, and Mr. Goldman already has a comment, go ahead.
Is it okay if I just stay?
Yes, you can all stay seated. Yes. Yes, of course.
So in count 7 of 12, for the said accused in County of Clark and State of Georgia, did perform a sex act with the person of Tara Baker involving the sex organ of and
What?
8 in front of.
Okay. All right.
At the bottom of page 3, after Edrick Faust, the word with the offensive rape.
Right. See it? Thank you. Anything else with regard to page 3? All right. Mr. Hill, Mr. Cruz, are you okay with page 3 after the correction? And the word with. Okay, we'll go on page 4.
Top of page 4, the second line, it says January 2001 did have carnal knowledge of Tara Baker. However, in the indictment, oh, no, I'm mixing them up. Please forgive me. I missed
Okay.
Disregard that.
Okay. Page 4, Mr. Bolden, anything from the state about page 4?
No, Your Honor, and I'm just going all the way to
Okay.
the bottom of page 5 to get through.
Okay.
Our indictment, and I didn't see it.
Okay.
I'm still on page 4, Your
That's fine, absolutely fine. I just want you all to know, page 6, in the very top, there's a typo. It needs to be his instead of her, but we'll get there. Those are the easy things to correct.
All right. No issues with count 4, Your Honor.
All right, page 4. We'll go to page 5.
All right. One issue in count 12 of page 5. Just the word on is missing. Word on or about the 19th day of January 2001.
All right, let me just make sure that's what the. Okay, that's exactly right. Let's see. On, we're going to put an on before the or.
Also, count 12, the last line of count 12, well, the third line from last count 12, where it says laws of said state the good order in peach instead of peace.
You got it. Peach does not fit. Okay, excellent. Thank you. When you get to page 6, the very top should be his as opposed to her. So that's the first thing we need to change. When you're ready, if you all go through page 6, let me know what your position. Okay, I just want to remind you all, Ms. Ells made a good point. Everybody's requests are in this document. We haven't taken anything out, state and defendant. So it's a big document. Obviously, we'll figure out how to pare it down properly, but just so you know, everything you've submitted is in here. Yeah, sure. Yep.
The bottom of page 5, just the hyphen in between not guilty.
Well, we typically have it in there. I'm not sure why we do, but if you would like us to take it out, we certainly can. All right, we'll do that. I think it just reads better, but we certainly can take it out.
In the second paragraph of page 6,
Yes.
the 4th line, where it says defendant is guilty of the offense charge, or just change it to offenses.
I have to figure out where you are. Hang on just a moment.
Second full paragraph. Well, the first full paragraph. First full paragraph. In the 4th line.
Well, I think we always have it as crime, just because I think it indicates that they have to individually apply this reasoning to every single charge. And so I see what you're saying, but I think we're going to leave it in there just because I don't want them to misconstrue that they have a responsibility that's not individual to each charge. Yep.
Where it says there is no burden of proof upon the defendant, the word whatsoever is missing. And that is the second full paragraph, 3rd line.
All right. Let me look at the pattern. I've taken this from my standard jury instructions, and I'm not sure I have that word in there. So we'll look at the pattern for burden of proof and see what it says. Certainly want to follow the pattern. All right, this is the pattern.
That'll be the fourth paragraph of the pattern.
You're right. It says whatsoever. There's no burden of proof upon the defendant whatsoever.
While you have that pattern, Judge, is also missing
Okay.
language of that same line. And the burden never shifts to the defendant to prove.
Well, it says to prove innocence in the pattern. We have the word his, but we can take his out.
Well, no, that's not.
Okay.
It says, and the burden never shifts to the defendant to introduce evidence or to prove innocence.
All right. Mr. Bolden, any objection to increasing the language of the pattern charge and putting in introduce evidence and what? Introduce evidence or to prove innocence?
That is what the pattern says.
Okay.
Mr. Cruz wants that.
Yeah, no, I agree. And I think I'm going to change my patterns in the future to reflect that, since the pattern says that. They do change a lot of these patterns kind of every 6 months, and it may be that that has been changed and I didn't realize it. So we're going to add this to paragraph 2. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove his innocence. And I'm going to keep the word his in there unless you don't want me to, Mr. Cruz. All right.
Can we copy the pattern language when we get into the definition of reasonable doubt?
Tell me what you mean.
Verbatim?
Hang on one second. I just need to send this message to another attorney about a case from Monday. So hang on just a moment. Okay, go ahead, Mr. Cruz.
Pattern language, and it's not a big.
Tell me where you are. Tell me.
I am on the 5th paragraph of the pattern charge, starting with sentence 2.
On what page?
Page 6 of the.
Okay, hold on. All right, you're asking about the reasonable doubt pattern?
And page 6 is the last paragraph. So the pattern charge. I apologize. The pattern charge states a reasonable doubt means just what it says. I believe that matches. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. And I believe Your Honor has the pattern charge up. Yeah, can we just use the exact language of the pattern charge?
Well, we have all of this in here. I guess, is it just because it's in a different order?
Yes, ma'am.
We need to start with the burden of proof. Well, we have, I mean, it is in here exactly the same. It's just in different paragraphs. I think
So the
it is exactly the same.
okay. So we're
It's the pattern as written is reflected in the charges. I think maybe the difference is the statement, however, the state is not required to prove the guilt of the accused beyond all doubt or true mathematical certainty is in the paragraph above it.
no, that's fine.
We can move that to the paragraph below as it is in the pattern, but the order in which those phrases are or those sentences are done is exactly here. I think it just looks different, but I can move that sentence, however, to the next paragraph if you'd like.
So the difference I have in mind is the pattern charge, and I think generally it says the same thing, but we're really big on language, and I'm very careful on language. In closing, it says it is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. And it says essentially the same thing, but the pattern charge says a reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth.
Repeat the words a reasonable doubt. Yep. I think that makes sense.
And I ask this, if it's not too much, can we just copy and paste that paragraph from the pattern charge and stick it into the charges?
Well, it is the same, with the exception of what you just presented and the fact that however, the state is not required is actually part of that paragraph in the pattern. In our documents, it's part of the paragraph above it.
And that's no issue. That's no issue.
But the rest of it, I think, is exactly the same, except for the words "a reasonable doubt," mentioning it again, which I will do. But I want to just make sure that put down again a reasonable doubt on the second line. Okay, so this is how it's going to read, and this is what the pattern says. However, the state is not required to prove the guilt of the accused beyond all doubt or to mathematical certainty. We can put that down to the next paragraph and just make it one paragraph. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror who is honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt, and the rest of it is the same. Does that satisfy you, Mr. Cruz?
Yes, ma'am.
Okay, that's exactly what the pattern says. All right, and anything else on page 6?
I'm on the last.
Golden, if you want to jump in there while we're having this conversation, obviously do that.
Of course, Your Honor. State has no position.
Okay, all right. Okay, yep. When you're ready to go to page 7 and let me know what you think about page 7.
I included grave suspicion of guilt.
I'm sorry? Yeah, we haven't gotten there yet.
Okay, got you.
Yep. What you all are reading that goes through top of page 10 are the standard patterns that all Superior Courts here at least have in their arsenal. And obviously these are ones you all have asked for, but it's our standard ones. And so we haven't gotten to the specific ones you've. Yep. Yeah. So everything you all have asked for, we haven't kind of gotten to that yet. I mean, the specifics.
Yes, ma'am. All right. With the jury instruction, jury judges of law and fact,
Which page are you on, Mr. Cruz?
7.
Okay.
Just the last sentence says, it then becomes your duty and responsibility to apply the law that I give you in this charge to the facts as you find the facts. Okay. It's nothing that needs to be changed. Attention.
All right, are you all still on page 7, or have we moved on to page 8?
I am, Your Honor. I'm
All
looking.
right, okay. Mr. Bolden, are you still on page 7? Okay. You okay with page 7?
Yes.
Okay.
Sorry.
Nope, that's fine.
All right. No other objections. Page 7, if I'm
All
not
right,
any.
we'll move to page 8.
What's the site site for evidence is the means by which any facts which are put into issue is that established or disproved? Do you know the site for that one?
You mean the pattern number?
Yes, ma'am.
Well, it's really hard to look from up.
I think I just found it. I think it's 1.3010. I think I just found
Got
it.
it right here. Yes, what about it, Mr. Cruz?
Is that it? No, I just wanted to find it. That was it.
Okay.
Just to match it up.
The instructions that we have that we use don't make it easy to like search. We do it in order, but it doesn't make it easy. This is a Crocs issue.
Your Honor, as it relates to that, on the top of page 8, pattern does read that evidence includes all of the testimony of the witnesses, parenthetical, and any exhibits submitted during the trial. And then the next parenthetical says stipulations of the attorneys, which I think would be applicable here because we do have the one stipulation as to the photo of Mr. Faust so the photo was entered into evidence, but then the stipulation was also that it was a photo taken of him on, I think it's February 8th of 2001. Mr. Yalamanchili put that on the record at the time that the photo was tendered.
Okay, so you're saying this is the pattern. Evidence includes all of the testimony of the witnesses and then parentheses, which I don't think is applicable.
Correct.
The equivalent, such as depositions, so we'll leave that out. And any exhibits admitted during the top trial, stipulations of the attorney said is any, okay, so do you, I could, well, and I'll hear from you, Mr. Cruz, I could just do it this way. With all the testimony of the witnesses and any exhibits admitting during the trial and any stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court, period.
That would be how the state would ask that the court.
Mr. Cruz, how do you feel about?
I have no objection to that, Your
Okay,
Honor.
so we'll do it that way. Oh, no, okay, hold on. I have your computer. How could you have gotten? All right, so what we'll do is input the word and any stipulations of the attorneys, put that all in there, and then not matters of which
And then I would also say, I don't know if this was in the requests that I made this morning, and if not, I apologize, but I think that does make the next one in the pattern, which is 1.30.12 applicable, which is the pattern on stipulations.
All right, we're going to look it up in just a minute.
I apologize.
Well, I mean, this is what this is for.
Sure.
We have to, you can also make oral motions for certain charges. I mean, that's obviously why we're here. So let me let her finish 1.30.10 and then might have added to this case specific one. So if it is added in, we should put it there. That would make sense.
Yes. I apologize.
It was?
It was not.
It was not.
So it would not be in there.
Okay, so I think, okay. 1 point, okay, so Mr. Cruz, in case you don't have it in front of you, 1.30.12 says, okay, I was trying to figure out where it was. So there are several, let's all look at 1.30.12. There are several things that could be well, I'm just going to throw out what I think, and then I'm going to listen to what both of you want to add. There's only been one stipulation, and I think making providing all this emphasis would be very confusing to the jury. This would be my sense, but I'll hear from both of you. To just put in there, the parties have entered into a stipulation that has been approved by the court about however we decide it is about the picture, and leave it at that. The rest of the statute is pretty convoluted about probably convoluted stipulations. And so that would be sort of my.
And that would also be the state's position and request, Your Honor. So again, under that pattern charge, 1.30.12, just that the parties have entered into a stipulation that has been approved by the court about the following exhibit, whatever exhibit number that would be, and then that was a photograph taken of the defendant on February the 8th of 2001.
I think you both have to come up with the language that suits you both. Before we get into that.
Sure, I apologize.
Sure. No, I mean, you don't I have to apologize. I mean, I just think we need to talk about what the language is. Mr. Cruz, without getting into what language is the exhibit that describes the exhibit that's been stipulated to, do you have any objection to 130.12, which is the parties have entered into a stipulation that has been approved by the court about the following? about the following exhibit?
I do not.
Okay, so let's talk about, so we'll put that in there. Let's talk about how to phrase it. Let me get his you say again, Mr. Bolden, what you think it should say?
Yes, Your Honor, I would say that, so the parties have entered into a stipulation that has been approved by the court about the following exhibit. And then in the pattern where it says specify, I would suggest something to the effect of that state's exhibit, whatever the number is, and I'll find that out momentarily, was a photograph of the defendant as he existed on February the 8th, 2001.
Okay. Cruz, thoughts on that language?
That's what we agreed to.
That's what I thought. So I hope.
Are you satisfied with that, Mr. Cruz? Okay. Will you say it slowly so Ms. Ellis can take that in?
I will. I probably won't be able to do it exactly the same way, but I will try. That state's exhibit blank, which I can fill in due course, is a photograph of the defendant as he existed on February 8th, 2001.
Okay. I have 113. I have that as a stipulation, but I didn't label in my notes what the stipulation was. So we need to double check and make sure it's 113. We can do that when we're finished, but let's make sure we actually get that in there. Okay. Let's keep going on page 8. Okay. I'm going to read this to you all since Ms. Ellis has just redone what you have said. The parties have entered into a stipulation that has been approved by the court about the following state's exhibit 113 about, I think we should just say about state's exhibit 113. I'm going to just say about the state's exhibit 113, unless you all have, it just sounds better. About state's exhibit 113, a photograph of defendant as he existed on February 8th, 2001, where parties stipulate, let's see. Where parties stipulate facts, this is in the nature of evidence. You must take that fact or those facts as a given without the necessity of further proof. You make all decisions based on the evidence in this case. Where parties stipulate exhibits only, this is in the nature of evidence. You may take that testimony as if it were given in court, and you may rely on it if you find it credible. However, either party may dispute such testimony by other evidence. You make all decisions based on the evidence in this case. That is the pattern. Mr. Bolden, I'll ask you first. Any thoughts on all of that?
That's acceptable to
Okay.
the state, Your Honor.
Mr.
Thank
Cruz? All right, we'll move on to page 9.
Your Honor, on page 9, at the very, or not at the very bottom, but towards the bottom, to impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. I see that that's the 1.31.45. I guess the state's concern here is I am not certain that anything has been disproven as to what they testified to. I understand that the defense would maybe disagree with whether or not their credibility, and that's a separate instruction. So the kind of that particular pattern gives an either or. The first part says impeaching a witness is to show that the witness is unworthy of belief. Then there's the or. The credibility of a witness may be attacked by disproving the facts to which the witness testified. I mean, it's my position, it's the state's position that second part would actually be more tailored to this case.
The whole okay, so you want to go to page 21.
My page.
Okay, hold on. Let's fast forward to the okay, the defense number 11. Let's go to defense number 11 and look at the whole pattern in total, and then we'll discuss it. Since what we did was we included everybody's requests and didn't take them out, even if they touched on something ahead of time. So on page 21 in the middle is defense request 11, which is the pattern. All right, Mr. Cruz, do you care to be heard? Which of those portions of the pattern you think we need to have?
I believe the first one. I think a big, 21 is large. So let me start there. Well, where we starting on page 21?
It's the one right in the middle, 131.45.
Okay.
You're 11.
So I would say to impeach a witness is to show what Mr. Bowden read into the record.
Yep.
Witnesses impeached each other during this trial. We use certain witnesses to impeach other witnesses. I think a big one that sticks out vividly is, I believe Ricketts was extremely adamant that Chris Melton's alibi had been confirmed. And we went through with other witnesses establishing that it had not, in fact, been confirmed. And I think a big part of our cross was locking Ricketts deeper and deeper into his statement that we confirmed it. And I even think a little bit with Ricketts, we started going with him through some of the places that were unconfirmed that he ended up admitting. So and that's just one example. And I think a second example was Mr. Melton, who refused to acknowledge that he was living in his parents' basement at the time. And obviously because we showed him the photos with the doors showing how he could get out. However, Josh McCourty was the witness that came in right behind him and said, oh, Chris was staying in his parents' basement. So we would ask for that instruction. We intended to use it in closing.
How would you both feel if the court included both of them in the manner in which it is in the pattern, which is disproving the facts to which the witness testified, or let's see. I don't know, including both of them. I'll have to think about how to do that.
I don't have any objection to including.
I don't want it to be confusing, but Mr. Bolden.
I mean, I guess it gives, but my point is still that I don't know that that's actually disproving anything that another witness testified to. I understand Mr. Cruz's position, but I think Agent Ricketts' opinion that Mr. Melton's alibi was confirmed is like that's getting into kind of the subjective nature of his assessment of the alibi, and you can't disprove something that is a subjective belief in someone's mind. If it was an objective fact, I think that's really more what the impeachment statute and the impeachment pattern is designed to cover. Again, I think that it will all be covered in, credibility and stuff like that. And that's the only reason I bring that up.
Well, I'm not going to make any comment on the evidence.
Sure.
The strength of the evidence. That's for the jury to decide if they choose to. about these particular moments we've been discussing. So I think it would be appropriate to include the entire pattern as written. And I think I'm going to do that. I'm going to grant your request, Mr. Cruz, and have, let's see, I think we need to put it, defense's request 11 in, on page 9.
Question for you. On the bottom of page 9, your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony. Where is that located? The pattern number.
I don't know exactly. I mean, those are our standard charges that we have from pattern. And I always read those, and I'm going to continue to read those. But I will find this. I will find the pattern for you. But let's just jump on top.
I see that one.
Let's jump to the impeachment first and get that squared away.
Yes, ma'am.
So we're going to keep in defendant's 11, defense's 11, and it's going to read, let's see, exactly how it is. It's going to read exactly how it is. As you've requested, it's already in the instructions. But let's talk about credibility of witness. Let's see. I'm just going to put in there, and I'm doing this over objection by the state. This is how it's going to read. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. The credibility of a witness may be attacked by disproving the facts to which the witness testified. I'm just going to put both of them in there. I know the pattern says or. I don't think it'll be confusing. I don't want to comment on the evidence. I'm just going to put the whole thing in there. So we'll put it in that area on page 9 where it starts with to impeach a witness. Does that make sense? Okay. All right. Let's go to then the next paragraph. You had a question about that, Mr. Cruz?
I did not. I found it. I was just
Okay.
trying to match
All
it
right.
up.
Anything else about page 9 from the state of the defense?
No, ma'am.
Let's go to page 10. And then page 10, right after the very first paragraph, is where we start to put in the requested charges. Yes, and we're sorry. Ms. Ellis wanted me to make sure everyone knows we obviously pull the titles out. I don't put the pattern number in there. I don't know if some courts do that, but we don't. It just reads like a document. The whole thing reads smoothly like a document.
Yes, ma'am.
And Mr. Bolden, I wanted to ask you on page 10, after 1, 2, and 3, where there are 3 phrases in parentheses, are you asking for all 3 phrases to be in there?
I'm sorry, can you say that one more time?
Yeah, well, you have to be looking at the page to understand what I'm saying. It didn't make sense. Sorry.
No, that's all right.
Okay, so after 2, 10, 10,
Yes.
we put in your request 1, defense's request 35. Oh, I should ask you this too, Mr. Cruz. I actually just saw that it was also your request. All right, both counsel. With regard to 2, 10, 10, after where it says for malice murder, the state must prove the defendant 1, 2, and 3. The next paragraph, at the end of that paragraph, has 3 parentheses. Without justification, another one without excuse, another one without mitigation. I'm asking both counsel, do you want all 3 parentheses in there?
We can. I don't think it's applicable to this case. I think we may have filed a motion, I believe, letting the jury know that identity is the issue. We may even say it in closing that the sole issue is identity. But it's up to the honorable court. I have no position whether the honorable court includes it or.
Right.
Well, I guess it does, Nick, because it is the law. I think that is in the statute, if I'm not mistaken. So yeah, I think it would need to be included unless a particular one applies. And in this case, no one's arguing a particular one applies.
Yes, and I would ask that there be a period after the word kill. I'm not asking for any of the parentheticals. I don't think any of them are applicable.
So you're just asking rather it is the unlawful intent to kill, period, without the parentheticals. That's what you're saying.
Yes.
Okay. Mr. Cruz, any objection to that?
I have. For purposes of the record, I would say yes. I would just say to keep it with the statutory language. I don't disagree with Mr. Bolden as substance, but I do have to be aware of the appellate record here. So I would
Sure.
say, I would say
Okay.
without justification, without excuse, without mitigation, but I'll leave it to the honorable court's
Okay.
discretion.
I think I'm gonna take it out, and the reason I'm gonna do it is this: there hasn't been any evidence regarding justification, excuse, or mitigation, and so I think it would be confusing to the jury, and obviously that's one of the most important things to look at when you're dealing with charges. It also doesn't fit the evidence, and so I'm just gonna put a period after the word kill. All right. And then the next two paragraphs is part of that pattern, of course. You both have asked for it, but if there's something you're thinking about you want differently, let me know.
And the honorable court's ruling is supported by the pattern charge. It says charge only the appropriate language, adapt parentheticals to the indictment and the evidence.
Your Honor, I've moved on to page 11.
Me as well.
All right, very good.
I don't have any issue with premeditation, which we both requested. As far as motive goes, I mean, I requested it and we just copied straight from the pattern. State does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining if the defendant's state of mind at the time of the killing. State hasn't offered any evidence of motive, so I don't know that the second sentence is applicable here.
Let's talk about, before we do that, the 21011 that you both asked for, premeditation. Any objection to how it's written in the charges?
And I'm matching it up now. If you give me 30 seconds, Your Honor.
Sure. Oh, you're off. Okay. Say the number, 21011. Okay, we're on 21011. Premeditation.
And what's the state objection to premeditation?
Objection was to the
I
next.
have none to premeditation.
We're going to start on, we'll kind of go chart.
One at a time. I got you.
So motive.
So we're on premeditation, the 21011. Do you have any objection? You both requested it. Any objection to how it's written?
No, ma'am.
Okay, so we'll move on then to 21012, motive. The state has, you've both requested it. The state has asked to get rid of the second sentence. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Any comment on that, Mr. Cruz?
Well, I intended to use motive in our closing. And that sentence, although it says defendant, I was going to switch it to fit our evidence in this case. I would ask that it's included if any change is made. Defendant is fine with me, but if the honorable court wants to make any change, just defendant is fine. Defendant is fine with me.
I'm not making any comment on your closing at all, but I am going to get rid of that sentence because I don't think it fits the evidence with regard to the state's position of evidence of motive for the defendant.
Yes, ma'am.
But certainly you've made it clear you've talked about motive for other things, and you're certainly not prohibited from talking about that in your closing. So that it'll just read 21012. We'll read the state does not have to prove motive to prove murder. All right. The next one that you have both requested is felony murder. And we need to talk about how to articulate that. There are 4 counts, I believe, of that in the indictment. Count 2, 3, 4, and 5. So let's just talk about 21020. Any objection to how it is written? It's obviously the problem.
No, not how it's written, Your Honor.
I'm sorry?
No.
Okay. Mr. Bolden, any objection to how it's written?
No, Your Honor.
All right, let's talk about how to talk about blank is a felony, which I will define for you shortly. Yes. We're going to take the parentheses off where it says the state does not have to show that the defendant acted with malice to prove felony murder. Just leave it as a sentence. The next one is blank is a felony, which I will define for you shortly.
Can we, oh, I'm sorry.
Yeah,
I didn't mean
go ahead. No, go ahead.
In regards to that, can we state all, I think it's 4 felonies. Can we state all 4 felonies? So Ray, just state them back to back. And then when we move to 21030, we can say the same thing with the first blank with all of them, regardless of whether he or she. And then when we get into the definitions, if the state doesn't disagree, just to keep it from being confusing, we discuss each charge just back to back to back. So that way we note all 4 felony murders, we note all 4 underlying charges, and then we also note or give the definitions following. So we at least signal to the jury, there's 4, and here are the 4 in the definition of the 4. And it may kill 2 birds with one stone because it also gives them the definition of the underlying crimes as well that we're charged with.
I think there may be some agreement, Judge.
Tell me what you mean. I mean, whatever way it needs to read where it doesn't confuse people is fine with me. I just want to.
What in the way that I submitted it in the state's requests is where there's the blank at the bottom of page 11 would just be burglary, aggravated sodomy, rape, and aggravated assault are felonies.
Okay.
Which I will define for you shortly. I think that's
Okay.
what Mr. Cruz is saying as well done.
Is that what you're saying? Just
That is.
all in one are felonies, which
Right.
I will define for you shortly.
Right.
Okay. Okay, so it's burglary. Do you want it to say burglary to a dwelling or just burglary?
Burglary would be.
The indictment says burglary to a dwelling.
So we'll use the indictment language.
All right. So we'll do burglary to a dwelling, comma, and we're on 21020. Burglary to a dwelling, comma, aggravated sodomy, comma, rape, comma, and aggravated assault are felonies, which I will define for you shortly. Counsel, are we in agreement on that?
Yes, Your Honor.
Okay. Let's go to the next. Yeah, of course. You're the one doing this.
In the very beginning,
Mhm.
the grand jury has indicted the defendant with malice murder, felony murder. I just written burglary, should I put burglary to a dwelling?
Well, I guess the difference is that count 2 says burglary to a dwelling in reference to felony murder, but the count 6 says the offense of burglary. So I think it probably reads, that's accurate. Yeah. Okay. Let's do 21030, causation in felony murder. Both parties have requested this one, and it goes from 11 to 12.
I have no objections to that one, Your Honor.
And so again, kind of just like a minute ago, I think what the state would request is that you may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of burglary, aggravated sodomy, burglary to a dwelling, aggravated sodomy, rape, or aggravated assault. Kind of detract the language that we just talked about.
Any objection to the way that that's been articulated, Mr. Cruz?
No, ma'am.
Okay, we'll use the word or, regardless of whether he, not she. Okay. Any other comments about the top of page 12, which for our purposes is 21030? Any more comments on that?
No, Your Honor.
Okay, Mr. Cruz, are you satisfied with 21030?
Yes, ma'am.
Okay, let's go to 26221, burglary in the first degree. Both parties have requested it. Mr. Bolton, let me ask you first, since it's your burden. Number one, did you want both entered and remained in?
I was just looking at that, Your Honor. I think that's the way. Oh, where are you? I would ask that it have both entered and remained in, because those are both included in the charging language of count 6.
I would have, because you all's theory, I guess, that he entered the house.
Okay, it does, count 6 does say enter into and remain. That does track the indictment. I think it needs to say entered into and remained to track the language of the indictment. Mr. Cruz, do you have any objection to that change on the number 1? Okay, so we'll do that and get rid of the parentheses. Do you have that? Maybe we good? Okay. The intent to commit a felony. All right, let's go to count 2. And then we put in here well, I'm okay. Mr. Bolden, what are you asking the court to put in the blank?
In the blank, I would say aggravated sodomy and rape are felonies, which I will define for you shortly, because those are the specific felonies that are referenced in count 6.
Okay. Any objection to that language?
No, ma'am.
Okay. Let's go to the bottom of that pattern that you both have requested and let me know what you think.
Well, I guess we'll wait till we get to it.
I'm good through the bottom of page 12.
I am too.
Okay. All right. So we're going to start on the next one. I'm going to just make sure Ms. Ellis can follow with us. It's 26223, intent to commit a felony. All right. This is state's request 7.
Yes, Your Honor.
All right. What is your request?
Your Honor, bear with me just a second.
Okay. Okay. All right.
And on our copies that you provide us, it will have the title on our copies. Oh, it won't have any title.
No, this is the only version where you'll have the titles. So what we're going to do is Ms. Ellis is the master at all this. She's taking down all of our changes. She's going to incorporate it in the master document and delete, of course, all of the titles. And then what I do is I make a copy for every juror and every attorney and Mr. Faust. So everybody will have their own copy and it'll be the same that the jury is holding.
Okay.
I would, Your Honor, I think I would withdraw state's request number 7.
Okay. We're going to withdraw 26223. Yes. Okay. All right. We could email it to all of you when we're finished. Sure. All right. So let's, we'll get rid of that. All right. 26231. This is state's request 8.
we would ask that that be given.
All right, we're going to have to,
But I would, my suggestion as it relates to state's request number 8, 26231, would be to move that to until after the court defines burglary, which I think is later.
can we just do this? We just defined burglary and.
Okay, I'm sorry. Okay, I'm sorry.
Yep.
Yes.
Okay, so I guess my question is, how did you want 1, 2, and 3 of your requests to read before we get to Mr. Cruz's response? Or do you want it to read like that?
I would say just number 1
Okay.
would be the most
All right,
narrowly tailored to the case.
okay. Mr. Cruz, any objection to 26231 reading? To prove entry into a structure, the evidence only needs to show a breaking of the plane of that structure. This quote, breaking of the plane, end quote, must be done by the defendant. Any objection to that charge?
No, that's the pattern language.
Yep,
Your Honor.
it is. Okay, and we'll cross out 2 and 3. And we're going to cross out the number 1. We're just going to put in must be done by the defendant. Okay. The state does not have to show that there was an actual break-in to prove burglary.
Hold on. Say that. What are we doing now?
So we're on 26231. So on your copy, it's the middle of page 13.
Mhm.
And what the state has requested is this. To prove entry into a structure, the evidence only needs to show a breaking of the plane of that structure. This quote, breaking of the plane, end quote, must be done by the defendant. The state does not have to show there was an actual break-in to prove burglary. That's the request.
I understood. So we're taking out 2 and 3.
Yes.
Would the court consider giving the kind of not parenthetical, the example that is given in the pattern? I'm kidding. So about breaking the plane, football breaking the plane. I'm not requesting that. I'm sorry. I'm just kidding.
I'm not looking at the pattern. I'm looking at your.
Sorry.
All right. Any further objection, Mr. Cruz, or any comment?
Not at this moment, Your Honor.
All right, 23010, which is requested by both counsel. And of course, we're going into page 14. It'll be a different page, obviously, when we're finished. Mr. Bolden, any other changes to that request from the state?
No, Your Honor.
All right, Mr. Cruz, your request is 41. Any changes to your request?
No, ma'am.
All right, so it will be given as requested by both parties. We'll go to the next page, towards the bottom of page 14 for us. It's 23210 for Ms. Ellis. This has been requested by both parties. I'll ask Mr. Bolden first, any changes about how you want this charge to be? I mean, this is the pattern, so.
So, I mean, this is where it gets a little confusing because there are the 2 different aggravated sodomy counts. I don't know if the court's preference would be to charge separately on each of those counts, or if the court thinks giving the definition of the crime once and then kind of incorporating, as alleged in count. Bear with me.
Okay.
As alleged in count 7 to include the sex organ of the accused and the mouth of the victim. And then in count 10, the sex act or sex organ of the accused and the anus of the victim. Or if you just want to define it twice. Does that make sense what I'm trying to get at?
Yes, it does.
I mean, I don't know which way is less confusing. So I think that's why we requested it be given twice. I think that might be the easiest way. So, for state's request 10, for aggravated sodomy as alleged in count 7, The state must prove that the defendant forced, and then I'm looking at the top of page 15, only use mouth, and then give the rest. And then I realize I'm jumping ahead here, but then for state's request 11, that it read for aggravated sodomy as charged in count 10, the state must prove, and then use anus instead of mouth.
Okay, so you're asking some additional language, which is for aggravated sodomy as charged in count 7. That's what you're asking for. Count 7 of the indictment. The state must prove that the defendant, okay, and you want the word mouth, and then you want it read again in the same way as charged in count 10. Of the indictment. State must prove, and then the word anus. Okay. So you're asking then, with those additional words, to read it twice.
Yes, I think my personal opinion is that would be the least confusing way to explain.
Mr. Cruz, I'll hear from you about your thoughts. You had asked also for 23210. You had asked the same, you have the same request, but the state is the only one that asked for it twice, just given the 2 different counts in the indictment. So thoughts?
I'm fine with it twice.
Okay.
So I don't oppose that. I do have a question for you going back up to
Sure.
rape.
Hang on, just let me make sure Ms. Ellis got it. Go ahead.
All right. So, and if it's not appropriate now, I can add.
Oh, go ahead.
With the rape instruction, one of the elements is against her will. We did intend to argue that the state has to show that it's against her will, which I think is appropriate for their burden. I just want to make sure the honorable court is okay with that, where it doesn't violate anything.
Well, that is the state's burden, and that is the statute.
Yes, I think I understand what Mr. Cruz is asking. And I think that against her will is an element that the state is required to prove beyond a reasonable doubt.
Okay. Are you asking, Mr. Cruz, I want to make sure I understand what you're referring to. I mean, I do understand what you're referring to, but in the larger context of this trial and the motions that we've had and things of that nature, are you implying that because that is part of their burden, that you are going to argue anything about consent?
Absolutely not. Now, I will say this, Judge. I may disagree with your rulings, but I respect the court. I always have to respect the court.
And I wasn't insinuating you weren't. I'm just making sure I understand.
But instead of arguing consent, we're just going to put the burden where it belongs, which is on the state. And we are going to argue that they do have to prove that it was against her will without consent.
All right. Thank you. Anything further? Okay.
Understood, Your
All
Honor.
right. And are we then finished with 23210? Let's go back to page 15. Anything else from the state on 23210?
No, Your Honor.
All right, Mr. Cruz, are we finished with 23210 or anything else we need to talk about?
Court's indulgence, Your Honor. It's- But no, so we're going to do it twice, one for anus, one for oral.
That's correct.
Okay, let's go.
I mean, that's what you said you were fine with.
Correct.
Okay. All right. Let's go to the next page then. And to the state's request 23015 and of course then 23017. And the state has only requested these.
Yes, Your Honor. And what I would request is the way that what we submitted was a little bit more tailored, and I would just say that sexual battery, aggravated sexual battery not be included, that the state must prove that the alleged victim did not consent to sexual intercourse or aggravated sodomy.
Are you asking for the rest of it to be there too? If you find that the victim was not mentally or physically capable of consenting?
I mean, I don't necessarily know that that is applicable here.
Let me ask Mr. Cruz about his position on state's request 12, which is 230.
Court's indulgence, Your Honor. Yeah, I don't believe this applies to the facts of this case. Incapacity to consent is no.
Let's back up. I understood Mr. Bolden's comment that you are not asking for that language. Am I right about that? If you find the victim was not mentally or physically capable of consenting, you'd be authorized. Are you asking to take that out in your request? That's what I thought you meant.
Yeah, and
I agree with the first sentence, but just the following language, it doesn't fit the evidence in this case.
I would, the court doesn't want to get.
I'm not sure 23015 fits this case at all.
And I don't necessarily disagree, Your Honor. I think if the court were to incline not to give.
I agree. Yeah, I don't think it fits, but I think that first sentence is also in lack of consent.
Sure. Hang on just a minute. All right. Is there any objection to the court not giving 23015? All right, Mr. Cruz.
No objection to not giving 23015.
Okay, we're going to cross that out then, and then we're going to go to 23017.
I don't think I would withdraw that.
Can I look at the statute really quick, Your Honor? Not the statute, I'm sorry, the language.
I mean, the state is withdrawing it. If you wanted to request it, we can talk about it, but they're going to withdraw their request. But I'll certainly let you look at the statute and decide what you want to do.
Yeah, I believe 203017 fits the language because of the aggravated sodomy piece. And the particularly the oral charge of aggravated sodomy.
So tell me what you're asking, Mr. Cruz.
I'm asking for 203017 to be included in the charges.
Okay.
Thank you.
Mr. Bolton, any comment?
I'll leave it up to the court.
Sorry?
Whatever the court thinks is appropriate.
All right, if you have no objection and the the defense has asked for it, then I will leave it in. I was going to eliminate it based on our elimination of 23015, but if you all are basically in agreement, we will keep it in. And I think it just needs to read to the words of aggravated sodomy. I'll just take out the rest of it.
I agree with that.
Obviously. Okay. Let's go to, did you get that? 230? 17, okay. 230, I'm sorry, 220-21. Both parties have requested this. I think number 2 needs to be deadly weapon, would fit the evidence.
Yes, that's the way that it's
All right.
indicted.
Yes, it is indicted that way. So we'll cross out with an offensive weapon, put in with a deadly weapon. Okay, so with that change, both parties have requested it. Anything else, Mr. Cruz?
I'm matching up the language, Your Honor. Please forgive me.
Okay, that's all right. We'll go to page 17 also. In the top of page 17, we have to finish the pattern. I knew there had to be more to that pattern than just those 2 sentences. All right, when you're finished, go to the top of page 17 to finish discussing charge 220-21.
And so at the top of page 17, Your Honor, I would ask that the sentence beginning with the word however read as follows. The state must prove that the defendant attempted to cause a violent injury to the person, period. And that second parenthetical not be included. I think that would be based on the way the charging language in the indictment. I think that would be the correct way the correct way for the court to charge the jury based on the way the state has brought that aggravated assault charge.
Okay. Any objection to what Mr. Bolden has just stated, Mr. Cruz?
No objection, Your Honor.
Let's talk about the next line, though, and make sure we're all comfortable with that. An offensive weapon is any object is likely to cause. That's okay. That looks right. Any objection to that last sentence? An offensive weapon.
No, I would ask that not be given. I think that's just probably part of the pattern that comes in if you use the object which when used offensively language. But since here the state has alleged a deadly weapon,
Got it. Yeah.
I don't think that
Makes sense. Right. Yes. Mr. Cruz, any objection to eliminating that line, an offensive weapon is any object, et cetera, et cetera?
No objection, Your Honor.
Cross that out. Let's go to 2-2023, deadly weapon. And in deciding whether, let's see what this indictment says, a knife, deciding whether a knife is a deadly weapon. This is 2-2023.
Can we, I believe it's undisputed that the knife was a deadly weapon. If the honorable court wants and if the state is willing to agree to it, I am fine with an instruction if the court wants to tell the jury a knife is a deadly weapon. But I'll leave it up to the state and the honorable court.
You're agreeing to the statement, a knife is a deadly weapon.
Instead of this one, because I don't think either party disputes whether or not the knife was a deadly weapon.
Mr. Bolton, any comment on the offer by the defense?
I mean, I think that's perfectly fair.
Okay, so we'll just say, period, a knife is a deadly weapon.
Correct. I was going to say the parties have stipulated the knife is deadly weapon, but you can say it that way too. I think it gets the same message across, so we're fine with that.
Okay. Say that again. Sorry. Okay, so the next one, 16, okay, 26810, the state has asked for just A1, but the defense has asked for it too. What the defense asked for?
Let me read the statute, Your Honor. I'm trying to find it now.
So here's the defense's part. Okay. Oh, I see. Okay. A1. So there's no pattern. Is there a pattern? Oh, there's no pattern in this. Got it. Okay. I'm sorry, I wasn't following you.
Under the pattern, it just says OCGA.
Got it. Okay. I think A1 is the only one that fits. But you let me know, Mr. Cruz, when you're ready.
Okay. I agree with A1, Your Honor.
I'm sorry?
I agree with A1.
Okay, all right, so we will.
I'm
give
sorry,
it-
I've gotten lost. Where are we?
We're on 26810 arson, but of course, it's just the statute.
Okay.
And the defense agrees that what the state has asked for, A, and then 1 is what's appropriate.
Well, oh, go ahead.
See. Yes, I think we should take out the letter A and the number 1. Sure, let me just read it again. He or she knowingly damages.
And if I could be heard,
Yes,
I think what the state would ask, if the pattern only says to look to the statute, and I think that's what I understand, then I think the state's request would be that this charge read, a person commits the offense of arson in the first degree when by means of fire, there's no evidence of explosive here, he knowingly damages any dwelling house of another without his or her consent, period.
I agree with that.
okay.
No
He,
objection to that.
okay, so he knowingly damages, I'm sorry, he knowingly damages,
And instead of he, can we use the defendant? Oh, I guess it's the same.
I think it's probably more appropriate to say he as opposed to defendant. Yeah, I think more general in nature makes more sense. By means of fire, he knowingly damages any dwelling or house of another without
His or her consent,
his or her consent,
period.
period. Okay, and Mr. Cruz, you don't have an objection to that?
I do not.
Okay, so that's how we'll give it. Let's do the next one, arson, presumption of accidental cause, state's request 17, 26816. Let's see what the damage by means of fire is what's in the indictment. Damage by fire, so we're going to cross out the word burned just for starters. And I think we cross out or as a party to it. There's no evidence about that.
Yes.
Thank you.
All right, Mr. Bolden, anything further we need to change from your request before I ask Mr. Cruz?
No, I think it's an appropriate statement of the law, especially when arson is charged, that they're all presumed accidental. So,
Mr. Cruz, any objection to the state's request 17, which it would read, the burden rests upon the state to prove beyond a reasonable doubt that the building described in the indictment was damaged by fire. Number 1, the building in the indictment was damaged by fire. 2, the burning was caused by a criminal act. And 3, the accused was the person doing the burning. Any objection to that?
No.
Okay, and then the paragraph below that about the law presumes every fire to be accidental or naturally caused until the state shall prove beyond a reasonable doubt that such fire is the result, etc. Any objection to that language?
No, ma'am.
Okay, we'll give it as requested with the changes that we just made. All right, let's look at 24040. State and defense have both requested this one. Let's see. We'll put on his person as opposed to his, her, or within arm's reach of his person. We can talk about what you all want. All right, let me ask the state first, and then I'll ask the defense what you want. Mr. Bolden, what do you think 24040 should read?
yes, Your Honor, I think that it should read that for the possession of a knife during the commission of a felony, the state must prove that the defendant had a knife with a blade at least 3 inches long on his person while committing malice murder. Because that's the way that
Okay, that's
it,
what's indicted.
it is indicted, which is a crime involving another person.
Okay. Which is one of the following, which is a crime against another person.
Yes, Your Honor.
Okay. Mr. Cruz, any comment on how the state has asked for that charge to be given?
None in that manner, Your Honor.
Okay. So it'll read this way. For 24040, it'll read this way. For possession of a knife during the commission of a felony, the state must prove that the defendant, 1, had a knife, 2, with a blade at least 3 inches long, 3, on his person, 4, while committing malice murder, a felony, which is a crime against another person.
Yes.
Anything? State satisfied? Is the defense satisfied with that?
Yes, ma'am.
All right, thank you. Let's go then to the next page. We'll cross out the controlled substance, obviously, information at the bottom. 130, 130. Both parties have requested this. Mr. Bolden, what part of 130, 130 are you asking for? I'm not inclined to put in the 11th Circuit information. I mean, I'm inclined to just stick with the statute. I mean, the statute, the pattern. But I'll hear from both of you about including the extra language. I think the extra language is taken care of in the pattern.
Yeah, I would agree with the court to give that the first 2 paragraphs and then not the pattern jury charge from the 11th Circuit. I have no problem with that, Your Honor.
Mr. Cruz?
I believe it's the same. So,
Okay. All right, I'll cross out the 11th Circuit opining because it's really taken care of in 130, 130. Okay, 130, 140. And this was requested by both parties.
so can I go through this one with you, Your Honor? Kind of save the court some time. So I don't think anything came out for character and truthfulness. I was on cross, so I didn't bring in any reputation, evidence of opinion or other witnesses regarding a person's character for untruthfulness, bias towards a party. Now, I believe I elicited it, but I will at least say I attempt to elicit it through Detective Ricketts when I asked him specifically, why are you defending Chris Mellon? And the purpose of that question was to support that charge, Your Honor.
All right, so let's do this in pieces.
Okay.
You are offering that the component of 130, 140 that applies to character for untruthfulness is not applicable.
Correct. That is not applicable.
Let me ask Mr. Bolden, any comment on that?
I don't believe there's any character for untruthfulness.
I agree with both of you. Okay. Mr. Cruz has made an argument to keep in bias toward a party. We got to read how to do that. In general, do you have a comment on Mr. Cruz's request?
And I'll pull up the statute just in case.
There's nothing about criminal convictions. We're going to get rid of that.
So I guess my position as to bias is I don't think that this is the pattern charge that would relate towards bias in the way that has been shown in this trial. I think it would go to the credibility, the general credibility charge, which I can't even remember at this point if we've discussed or if we will discuss, but that charge has the language about how they may consider their, manner in testifying, the facts about which they testified, and any bias. And I'm paraphrasing because I can't think of it right this second, but that would be.
And I could fully flesh out that argument, John, in regards to bias. I think that was just one component of it. A bigger piece of it was once the investigation started in regards to Mr. Faust and our examination with Ms. Bigham, and the larger piece of that argument, without going into all the other components, the larger piece of that argument was, if I can remember the statement, and I'll paraphrase the statement, when we had the discussion during the examination regarding the statements made to Chris Melton regarding the actions he should take moving forward. So I do believe we brought in different pieces of evidence through testimony supporting that charge.
Okay.
And the state is the party, just to make it clear, the
I
state is.
understand what you're
The
saying.
state is.
I want to just see if we've kind of given it in another way.
Sure.
And
The statute. Yeah, go ahead.
what I was referring to is 1.31.10, where it says that credibility of witnesses, the jury may.
I keep doing that to you. All right, hold on. We only have one computer. Let me pull up 131.10 before you get started. And I don't want to lose what Miss Ellis is doing on the computer. But all right, go ahead, Mr. Golden.
Yes, Your Honor. So that again, like I think we've already gone over that particular charge, but if not, I know that we will. But
It's in the beginning of the charge. We have gone over it.
and so the jury will have been charged on general credibility, and part of that is their interest or lack of interest in the case. So I think that's the type of. I think that's what Mr. Cruz is getting at. I don't think that bias towards a party shown by bad acts, being specific instances of the conduct of the witness, which is in 131.40, is what is contemplated here. So I would ask that it not be given. I know that was part of our requests, but that was anticipating what some of the potential evidence today may have been.
All right, thank you. Mr. Cruz, anything further?
I would just stand by my argument, but I'll leave it to honorable court's discretion.
So I think I agree with the state in terms of this particular pattern, and I don't disagree with your assessment that the issues concerning whether you want to call it bias or interest or lack of interest has been brought up by the evidence. I mean, I think certainly both arguments support that, but we're talking about the pattern, and the pattern, I think it actually would be very confusing to give this charge in the manner in which it is patterned, because it does talk about bias and bad acts, and that doesn't comport with the evidence. So I'm not going to give it in this manner. I do think the issue of whether you call it bias or interest or lack of interest in the case has already been given at the beginning of the charges, and so I'm just not going to give 131.40. I think it would be very confusing. It doesn't really comport with the evidence in the manner the pattern provides. So, all right. So we'll move on to 131.45, and I think we've already talked about this. We already have this we've already given this earlier. Let me just make sure. You moved to 131.45. Okay, we're good. All right, let's move on then to 131.47. The defense has requested prior statements.
I don't have any objection.
All right, and let me just read it. Anything further, Mr. Cruz, you want to say in your request?
No, ma'am.
Just as this, all right. All right, I thought that, don't we already give this? I mean, I don't have any problem giving it, but I want to say we already, I feel like this is in our.
It is.
Yeah, okay, I'm not going to give it twice. So let me just find it, what page we're on, but we already give this. Okay. Yes, it is. It's the bottom of page 9. Yeah. Okay. So we're not going to give it again. We've already given it, but your request is granted. Okay. 13190. Is that not also in the? Okay, that's not typically in there. I give it all the time. That's why I'm sort of thinking. Okay, 13190. Both parties have asked for 13190. Mr. Bolden, anything else?
No, Your Honor.
Okay. About that. Mr. Cruz, 13190, single witness. Anything else you want to offer with regard to that?
No, ma'am. No, ma'am.
I will give it. 13216, statement of defendant. You both have requested it. Right, I think at least the while in custody is appropriate.
Was it shown that he was in custody in that video?
Yes. The evidence was presented that they asked to remove the handcuffs, and that was shown. Yeah. What's 134? We're going to pull up 134. You both have asked for this. Mr. Golden, anything further you want to ask for?
No, Your Honor. I think that both of the parentheticals would be applicable here.
So how are you asking it for it to be read? Obviously, we're going to get rid of OCGA 24.
Sure. Just exactly as it reads.
Statement was voluntary, comma, if the statement was given in custody, whether the defendant was properly advised of his constitutional rights. Is that correct?
Yes.
Without the parentheses.
Yes.
All right, Mr. Cruz?
I'm reading it, Your Honor.
Okay.
1 second.
Well, I just asked both of them how long it would be. This was the more than a minute. So I guess I haven't heard that. I mean, I don't know that we can get to it. Okay. Oh, okay.
All right, no objection. Obviously, we're removing the limiting instruction conditional admissibility language.
I was just reading that 13450. I don't think it applies, but I mean, I'll hear from you if you think otherwise.
No, it doesn't apply to that.
Okay, so are you satisfied with the way you both have asked for 13216? Are you satisfied with how it's written there without the parentheses?
Correct.
Okay, we will give it 13217. Both parties have asked for it. I think I'm going to, as you go through 13217, next page 23, the top, I'm going to get rid of the statement in determining voluntariness because we basically said that twice, and I don't want it to be confusing. I don't think we need that, but I'll hear from both of you. Mr. Bolden, do you have any objection to just 13217 as
No, Your Honor.
on 22? Okay, Mr. Cruz?
I'm reading it, Your Honor.
This is a request by both of you.
Okay, you're saying on page 23 at the top, you were taking out.
Yeah, it's been said several times, and I just think it's.
Okay. But otherwise, I have no objections to the vote.
Okay. All right, let's do 13218, next page, page 23. The defense has requested this one.
And Your Honor, understanding that Mr. Cruz and I might disagree over the legality of the detention based on our motions back in the fall. I would object to this. I don't think this is the type of situation that charge is designed for. If the court were to give it, I would ask that it read as follows. You may consider the duration and conditions of detention as factors relevant to the question of whether or not a statement was freely and voluntarily made, but not give what's in the parenthetical.
You offered this.
I just double check it, please, Your Honor. I would request it, but I would leave it to the honorable court's discretion.
I don't think it fits the evidence. And, you know, I think it would be confusing. There's been no evidence concerning this particular kind of a charge. So I'm not going to give that charge. 132.19, burden of proof as to voluntariness. Both parties have requested it.
I don't have anything to add.
Anything further?
Just checking the language, Your Honor.
Right.
And I know our request, I just always double check the.
I know I'm going fast. I want to make sure you get a break before 2:30. So.
Okay. I'm fine with it.
All right, let's go to the next one. Constitutional rights. Both parties have requested that. We'll cross out her just for starters. Word her. Cross out she. We're going to want, well, first of all, any comments on 132.21?
No, Your Honor.
All right, what about, you both requested top of 24 where it says anything, and I'll cross out she, he said, wrote, signed.
I mean, I think if I remember correctly, when Agent Bigham read Mr. Faust's rights, she used the word said. And so I don't think wrote or signed are necessarily applicable.
I have no objections to the language, Your Honor.
We'll just cross out the words wrote and signed, and obviously the word she. Okay, well, the next one, 132.40, the defense has asked for this.
I think that's a.
We've given that in 132.19.
We did give that in 132.19?
Well, it's basically the same thing.
I think 132.19 is specifically to voluntariness. 132.40 is in regards to just the Miranda rights as a whole. Because I think with waiving a right is intelligently, voluntarily, and a little missing one. I want to say freely, but I don't think that's appropriate.
I would say that the state does not have an objection to 132.40.
All right. I mean, it is a bit redundant, was really my hesitation. And this is why. 132.19 and 132.21 deal with all of the things that are in 132.40. But
whatever the honorable court's rule.
well, you've requested it. And even though it's redundant, that was really only my concern. But if the state is not objecting, I'm not going to make a big deal about the redundancy. It's not overwhelming, but that was only my concern. Not that it isn't the proper law. So we'll give it. 132.50. Both parties have asked for this.
And so, yes, my only comment, Your Honor, is just get rid of the parentheticals at the end.
I have no No objection to that, Your Honor. And 13270, I would ask to be removed. I don't know how.
You're going to withdraw that?
I am.
Okay. Okay. So I guess my only concern, even though you both have asked for 13250, is again the issue of redundancy. I mean, we're sort of saying it over and over again, and in just slightly different ways. And so that's my only concern. But I'll hear from the state first, and then Mr. Cruz about that issue.
I mean, I would agree with the court that it is redundant. I just know that in every trial that I can recall in which a defendant's statement was played, I think there is just that extra caution to make sure a jury, and so I don't disagree with the court's the court's concerns about it being redundant, but given that it is all part of the pattern, I don't object.
All right, Mr. Cruz?
I would agree with the state.
All right, I'll give it. Let's go then to 25. We've crossed out 13270. We're on 134, limiting instructions. I don't think we had any of those.
Well,
Did we?
there could have been that 413 evidence, Your Honor. The state opted not to introduce that evidence, so I don't think it's applicable in this case.
I think we do have it in regards to Ms. Sims. You told me we could take it up at the charge conference in regards to her statement that what she tested was sperm, and we went through cross-examination, and then she said, well, we didn't, I didn't test it for sperm. I didn't know about the report that it was sperm. At the time, you told me to address it now. I would ask for a limiting instruction to the jury in regards to that statement that she made. And if the court is willing to give that limited instruction, I would ask for this pattern charge. But if the court is not inclined to give a limiting instruction, obviously this would not apply.
So describe for me, Mr. Gray, and I remember the conversation, but
Yes, ma'am.
describe for me why you think you can certainly talk about the limits of her testimony if you want to do that, certainly, regardless of whether she's tendered as an expert. I mean, you can certainly go there if you want to. But in terms of the charge, tell me how it applies to the request for.
Sure. The charge only applies if the Honorable Court is inclined to give a limiting instruction in regards to the testimony. If the Honorable Court is not inclined to give a limiting instruction in regards to the testimony, the charge does not apply. It's inapplicable.
Sure, but I guess
applicable to this
what
case.
limiting instruction would you be referring to? I guess that's what I'm
The
asking.
only thing I would ask, because there is no evidence of semen in this case. Outside of Detective Bigham saying that Chris Melton's semen was found, every other test, everything looked at in the testimony, no testimony came out in this case that semen was involved. When Ms. Sims, who just did the differential extraction, she started saying, and I may say the wrong, I think she said either semen or sperm, but she said one of the two. She started using that language. And that's when I objected and discussed saying with the Honorable Court. I would just ask the Honorable Court to give a limiting instruction to disregard. And she corrected it after I made the objection. She stopped referring to it as that. But just to give the jury an instruction to disregard Ms. Sims' characterization as the DNA evidence as sperm.
Okay, thank you.
Yes, ma'am.
Mr. Bolden, would you like to respond?
Yes, Your Honor. I don't believe that's what this pattern jury instruction is designed to address. The issue with Ms. Sims the other day, I don't want to, no need to get back into the evidence, but I think if Mr. Cruz had requested a limiting instruction at that time, I could see it. But this is designed for extrinsic acts and a court telling them that they can only consider that for a specific purpose. That's where it falls in the pattern. It's not applicable.
I agree. I agree with you there. I agree with him in that position. Looking at it.
Yes. Okay, so before we get to the next page, both parties are agreeing that 134 does not apply right now. We're not going to give 134.
That I
You agree with that? Is that right?
purposes or against some parties and not others, or for some counts and not others. Such evidence may be considered by the jury for the sole issue of purpose against. It wouldn't apply to what I'm asking for.
Okay.
But I would still ask for that limited instruction if the honorable court is inclined. But this wouldn't apply. I agree with the statement.
Okay. So I'm going to get rid of 134. I'm going to say with regard to the limiting instruction, based on how both parties have described the moment, particularly Mr. Cruz, your comment that it is the characterization of the evidence. I think if the court got involved at this point with doing what you're requesting, the court would be inserting itself into characterizing the evidence, which would be improper. So you can certainly argue and bring up however you choose to the jury. It's not limiting for you, but I think in terms of court charging the jury, it would be improperly inserting the court's opinion, which it doesn't have, of course, but sort of suggesting the court had an opinion on the characterization of the evidence, and that's not proper. I'm just going to do it in that way. But I'm not limiting you in describing however you choose to how the evidence played out. So I'm not going to give 134. Both parties have agreed to that. Let's talk about 134.10, which does require 134.
I would withdraw that, Your Honor.
Okay, I don't think it fits the evidence. Okay. All right, so the state is withdrawing that next one. All right. So now we're going to the next page, the middle of the next page, which is 134.20. And this was defense request. So I'll ask Mr. Bolden first. Any comment on 134.20?
I don't think there's any of that in the evidence in this trial. I'd ask that it not be given.
All right, Mr.
I can withdraw. I withdraw the request.
All right, we're going to withdraw 134.20. 134.30 needs to be withdrawn.
Yes, Your Honor. They will withdraw that.
All right. And the top of 28, of course, as well is withdrawn. 135.30. And this is the state's request.
I would just ask that it be given as charged.
Do you want the words or believability, which are in parentheses, to also be included?
Yes. Oh, I'm sorry.
You can offer your opinion. Go ahead.
Yes.
Okay. All right.
I don't have any issue with that.
Mr. Cruz, do you have any objection to how the state has requested 37?
I'm reading this statute.
Okay.
I'm in the pattern charge now, Your Honor.
I'm going to get rid of the words admissibility, maybe ruled on, et cetera, because that's not. Just that little part.
Well, I think this is the issue here because I'm just now seeing this wasn't DNA comparison. This was actually, and maybe I'm reading too deeply into it. From what I understand from true allele and DNA comparison, one type is where a human does it and they compare it. And correct me if I say anything wrong. True allele is like a computer program that just says, hey, this is the likelihood ratio that this DNA or this pattern of DNA compared to this person would show. I'm trying to use correct language. Would pop up among a random member of the population, if that makes sense. So, but we could give it. I have no objection to it.
All right. I think it fits the evidence, so I will give it as charged then. All right, the next one is defense's request, 140.10, definition of crime. That should have been given earlier.
It was.
Okay, so I'm not gonna do twice, but I'll grant your request, but it's already been given. 140.15, state's request.
And Your Honor, I the only thing that pops into my head with this request is the burglary count where we've alleged enter and remain within the dwelling house of another. Okay. You know, I know sometimes it's almost maybe it's almost better to wait and see if they have a question about like the and or, you know, conjunctive versus disjunctive. And so I would be okay with the court not giving it, with withdrawing that request at this time. But again, that I know that does happen from time to time, and then we have to give additional instructions. So that I think that was the rationale behind that.
Okay, so you're going to withdraw it, but that does come up from time to time. Yeah.
Well, I would object to the the instruction as a whole, because from what I understand from the indictment, everything is charged straightforward. And with the entering and remaining inside, I believe that's the state's theory of the case, that not only did Mr. Faust enter, but for a period of time, he remained inside and did these acts.
Okay. Any response?
Yeah, I mean, the state charges in the conjunctive can prove in the disjunctive, and I think that's very well established. But I think given all the other confusing aspects of the law, I don't necessarily want to interject another one unless they specifically ask. So I guess that's kind of the dueling concerns that I have.
Well, I think that it's probably best to address that issue this way, to not give it as charged. I do think it is probably confusing, and I agree with you, Mr. Cruz, in the concern about giving 14015, but it is an accurate statement of the law. And so I will just say this: if it comes up in a question, we're going to have to talk about how the court needs to respond to the question. And it may be that the court has to respond to the question this way, because this is the law, but I'm not going to give it as a charge. All right. 14112 is requested by the state.
I would withdraw that, Your Honor.
So that is withdrawn. 15010, statute of limitations. There hasn't been any evidence about statute of limitations.
Well, and again, this came up when we were talking about CODIS the other day, Your Honor. So on some of the counts would have statute of limitations issues, but that statute was told based on the date that law enforcement received the CODIS hit, and that is alleged in the indictment in multiple counts. I believe beginning with count 6.
Okay. All right.
On. And so, I think that's a material element that the state does have to prove. Now, the question is, I don't know what the statute is on some of these crimes, or at least what it would have been.
It's 4 years for felonies. I think murder, and I could be wrong on the murder one, so double check. I think it's 7 years if the person is known. If the person is unknown, it's an unlimited statute of limitation.
Well, and that's not, there's no tolling language alleged in the counts alleging murder or felony murder. It's the predicates.
So for the underlying felonies, 4 years is what I believe the window would be. But double check me. I'm never too certain.
I guess my concern, I understand exactly what you're saying. I think we have to figure out how to do this right, because there has been no discussion at all, and no evidence, I should say, no evidence at all about the phrase statute of limitations. And so this would be the first time, right, the jury would be hearing that. And so
I think it applies to the indictment, because they will have the indictment. Sure. And will have that language on it. And the state, that is something the state does have to, oh crap, we didn't get into that intro.
I guess the problem is the language of this indictment doesn't talk about statute of limitations in that sense. It talks about it in a different way. Perpetrator, yes. The crime alleged was unknown to the state of Georgia. So, I understand exactly what you're saying. I just think we have to tailor this so it makes sense. And maybe we do it this way. I don't know.
Can I have a second, Your Honor?
Of course.
I may have a motion. I just want to look up something really quickly.
So, Mr. Bolden, I would imagine on page 30, you would want me to put all the charges, the accused is on trial for the offenses of, and list all the charges, right?
Yes.
Okay.
And then I think it would, what I would then ask under Georgia law, prosecution for the offenses of,
And then list them all. Okay.
and then,
Prosecutions for these offenses.
well, so this is confusing. I agree with the court. So I would say that laws of our state sets a time limit upon the state in starting prosecution of most criminal offenses. The accused is on trial for
That's crazy that they got a verdict back so fast. I can't believe it. It is a verdict. Oh my Lord. Called it's Friday the 13th too, so I don't know. Let's see here. He about to bite the dust. Yeah, it's not Tanya, it's not on there yet. It looked like they just announced it, but as soon as it comes on there, I will definitely turn over there to it so we can watch it. But it looked like they ain't deliberate for long at all. I think they must be over him. Let me see. Let's see here. I'm going to make sure I have it up at Law and Crime. Also, it says a verdict has been reached. It was after 4 hours and 57 minutes and 33 seconds. So, verdict, 4 hours. Oh, so I can know 57 minutes and 33 seconds. Okay, and when the verdict comes in, I will bring it to you guys live. Let me turn my volume. And here we go.
And I would ask that the court read all of them and then say that under Georgia law, prosecution for the offenses of, and then start with count 6, burglary, count 7, aggravated sodomy, count 8, rape, count 9, aggravated assault, count 10, aggravated sodomy, count 11, arson, count 12, possession of a knife during the commission of a felony. I don't necessarily know that you have, I'm asking the court to read those count numbers, but say that under Georgia law, prosecution for the offenses of, and then list those 6 or 7 offenses. Those offenses must begin within 4 years after the offense has been committed. And then I think maybe the court could see where I'm going from there as to how to tailor it on 15011 and 15012.
Right, and I'll hear from you, Mr. Cruz, in just a minute. I'm trying to figure out how to do this. So you go from under Georgia law, prosecution for the offenses of what's in count 6, 7, 8, 9, 10, 11, and 12 within 4 years after the offense has been committed. In calculating this period of time, you should exclude from your calculation any period of time during which the evidence shows that B, the person committing the crime was unknown.
Exactly.
Get rid of everything else. And then we can talk about whether the language, if you find from the evidence that this case was not filed, blah, 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 we can talk about where that goes. When the statute of limitations is raised. I think we just say the burden is on the state. Get rid of when the statute of limitations is raised, because it hasn't been raised.
No.
So the judge is bringing people in on a Canero trial, guys, just so y'all aware. He's getting the courtroom situated, making sure he don't have to spank Sparky. Yeah, I guess it's gonna be verdict Friday. Yeah, it's verdict Friday. So the judge is up there. He states that he wants to give some instructions out before he does something with the alternates, just so y'all aware. So I'm gonna go ahead and just take us into the courtroom. That way we don't miss any. But if it's any downtime, it'd just be some downtime. So let me get it up here. Do
Folks, just double check your cell phones, please. Make sure they're on silent or off completely, please.
Okay, ladies and gentlemen, the jury has indicated that they have reached a verdict. In saying that, I just wanted to remind everyone that while reading the verdict, I'm going to ask, no matter what the verdict may be, I'm going to ask for everyone, you need to keep your emotions in check to the best as you possibly can. Obviously, everyone in this room understands the emotion behind this case on both sides of the aisle. We respect that. However, for purposes of the courtroom and trying to get through the verdict, I'm asking you to do your best to control that. And then once the verdict is done being read, you'll have the opportunity outside the courtroom to be able to do whatever you feel. And I respect that also. So can everyone follow that? We good?
Yes, Your Honor.
All right, thank you all. I very much appreciate it. And again, I understand. With that being said, I'm going to ask for the alternates to be brought. And just let me know.
All rise. Court is back in session.
Okay, we can have the Okay, everyone can be seated. Thank you. Mr. Foreman, I received a note at 1:54 p.m. It indicated that we have reached a verdict. Is that accurate?
Yes, sir.
Okay, and that includes all counts?
All counts.
Okay. All right, so we've marked that as CJ-6, the communication between the court and the jury. So I'm going to go through each one of the questions with you one by one, and you'll just answer the question after I read it, okay? All right. If you don't mind, can you stand for me? Unless you're uncomfortable. Do you have your verdict sheet?
No.
Okay, do you want to get that?
Yes.
All right. As long as he has his, you guys don't all need yours. Okay, sir, we'll start from the top. All right. How do you find as to count 1 of the indictment charging the defendant, Paul Canero, with the murder of Keith Canero?
Guilty.
Did the defendant, Paul Canero, commit the homicidal act by his own conduct, meaning the defendant actively and directly participated in the homicidal act?
Yes.
Did the defendant, Paul Canero, commit the murder in expectation of the receipt of anything of pecuniary value?
Yes.
Did the defendant, Paul Canero, commit the murder for the purpose of escaping detection, apprehension, trial, punishment, or confinement from another offense or offenses committed by him, the defendant?
Yes.
Did the defendant, Paul Canero, commit the murder while he was engaged in the commission of or an attempt to commit the crimes of murder?
Yes.
Count 2. How do you find as to count 2 of the indictment charging the defendant, Paul Canero, with the murder of Jennifer Canero?
Guilty.
Did the defendant, Paul Canero, commit the homicidal act by his own conduct, meaning the defendant actively and directly participated in the homicidal act?
Yes.
Did the defendant, Paul Canero, commit the murder in expectation of the receipt of anything of pecuniary value?
No.
Did the defendant, Paul Canero, commit the murder for the purpose of escaping detection, apprehension, trial, punishment, or confinement for another offense or offenses committed by him, the defendant?
Yes.
Did the defendant, Paul Canero, commit the murder while he was engaged in the commission of or an attempt to commit the crimes of murder?
Yes.
3. How do you find as to count 3 of the indictment charging the defendant, Paul Canero, with the murder of Jesse Canero?
Guilty.
Did defendant, Paul Canero, commit the homicidal act by his own conduct, meaning that defendant actively or directly participated in the homicidal act?
Yes.
Did the defendant, Paul Canero, commit the murder in expectation of the receipt of anything of pecuniary value?
No.
Did the defendant, Paul Canero, commit the murder for the purpose of escaping detection, apprehension, trial, punishment, or confinement for another offense or offenses committed by him, the defendant?
Yes.
Did the defendant, Paul Canero, commit the murder while he was engaged in the commission of or an attempt to commit the crime or crimes of murder?
Yes.
Did the defendant, Paul Canero, commit the murder while Jesse Canero was less than 14 years old?
Yes.
Count 4. How do you find as to count 4 of the indictment charging the defendant, Paul Canero, with the murder of Sophia Canero?
Guilty.
Did the defendant, Paul Canero, commit the homicidal act by his own conduct, meaning the defendant actively and directly participated in the homicidal act?
Yes.
Did the defendant, Paul Canero, commit the murder in expectation of the receipt of anything of pecuniary value?
No.
Did the defendant, Paul Canero, commit the murder for the purpose of escaping detection, apprehension, trial, punishment, or confinement for another offense or offenses committed by him, the defendant?
Yes.
Did the defendant, Paul Canero, commit the murder while he was engaged in the commission of or an attempt to commit the crime or crimes of murder?
Yes.
Did the defendant, Paul Canero, commit the murder while Sophia Canero was less than 14 years old?
Yes.
Count 5. How do you find as to count 5 of the indictment charging the defendant, Paul Canero, with the felony murder of Jesse Canero?
Guilty.
How do you find as to count 6 of the indictment charging the defendant, Paul Canero, with the felony murder of Sophia Canero?
Guilty.
How do you find as to count 7 of the indictment charging the defendant, Paul Canero, with aggravated arson as to the structure of 15 Willowbrook Road, Colts Neck?
Guilty.
How do you find as to count 8 of the indictment charging the defendant, Paul Canero, with aggravated arson as to the structure of 27 Tilton Drive, Ocean Township?
Guilty.
Count 9. How do you find as to count 9 of the indictment charging the defendant, Paul Canero, with possession of a firearm for unlawful purpose?
Guilty.
Count 11. How do you find as to count 11 of the indictment charging the defendant, Paul Canero, with possession of a knife for an unlawful purpose?
Guilty.
How do you find as to count 12 of the indictment charging the defendant Paul Canero with the unlawful possession of a knife?
Guilty.
How do you find as to count 13 of the indictment charging the defendant Paul Canero with theft?
Guilty.
Indicate the value of the pecuniary benefit the defendant received from the misapplication.
Check number one.
All right. So it's $75,000 or more.
Yes.
Okay. How do you find as to count 14 of the indictment charging the defendant Paul Canero with misapplication of entrusted property?
Guilty.
Did the defendant Paul Canero derive a pecuniary benefit from the misapplication?
Yes.
Indicate the value of the pecuniary benefit the defendant received from the misapplication.
One, 75,000 or more.
Okay, thank you. Count 15. How do you find as to count 15 of the indictment charging the defendant Paul Canero with hindering one's own apprehension or prosecution?
Guilty.
Count 16. How do you find as to count 16 of the indictment charging the defendant Paul Canero with hindering one's own apprehension or prosecution?
Guilty.
Okay. Thank you, sir. You can be seated. Ladies and gentlemen, you just heard the foreman go through each one of the charges and indicated the verdict as to all of you. At this point in time, I'm going to ask the deliberating jurors. I'm just going to go by your seat number. That's it. And I'm just going to ask, do you agree with the entire verdict as was read by your foreman, juror number one? Okay. Juror number two.
Agreed.
Juror number three.
Agreed.
Juror number four.
Agreed.
Juror number five.
Agreed.
Juror number six.
Agreed.
Juror number seven.
Agreed.
Juror number 9.
Agreed.
Juror number 10.
Agreed.
Juror number 12.
Agreed.
Juror number 13.
Agreed.
And juror number 14.
Agreed.
Okay. Our jury has been polled. Is there any reason for the attorneys to approach the bench?
No, Judge.
Okay. All right, ladies and gentlemen, I'm going to ask you to do me a favor at this point in time. I'm just going to ask for you to go into the jury room for a minute. All of you, you can all go in. I'm sorry. I wasn't looking up. I apologize. Okay. Mr. Canero, at this point in time, you no longer are presumed to be innocent. You have been convicted by a jury of your peers under 3:21-4A. You will now be detained and committed to the custody of the Commissioner of MCCI pending sentence. Your sentence will be scheduled for May the 12th, 2026, which is a Tuesday, and that is at 8:30 a.m. I will also, as a part of this, just so that the record is clear, as it relates to any motion for a new trial under 3:20-2, that there are 10 days from today's date for a motion for a new trial, which would be February 23rd. If the defense decides to file a motion for a new trial, the defendant's brief, I want everyone to have it now, will be due on March 16th, 2026 by 4:30 p.m. The state's response would be due by April the 6th, 2026 by 4:30 p.m. And the hearing date would be scheduled for April 20th, 2026 at 8:30 a.m. So again, if a motion is filed, those are the dates so that we do not have to come back for a briefing schedule. I'm giving it to you now so that we're all on the same page. At this point in time, what I'm going to do is I'm going to excuse the jury, and then I will excuse everyone from the back. All right. So I just ask everyone to stay put for a minute, but I wanted to at least get that finished and put on the record.
Grab all your stuff?
Yes, you can grab everything. No. Back in here. Okay. Everybody can be seated. Sorry, there was just something I had to handle before I excused you. So first and foremost, obviously, let me thank you. I've tried to do that a few times during the course of this, but at this point in time, now I lose control of you. You lose control of me, which is probably good for you. You don't listen to me anymore. But I want to say thank you. I want to say thank you for the time that you have put into this from the week of January the 5th. Some people on this jury were here on that first day. And have been here throughout the entire time. Our system of justice, if you remember what I said in the beginning, fails without people like yourselves for taking the time to sacrifice your time so that our system of justice can have jurors to come in and to render decisions on cases just like this. So the fact that you did that, and you did it, all of you did it with such professionalism, with dedication. I watched you each and every day. I told you before that you all paid attention. You very much were focused on the task at hand. And I commend all of you for what you've accomplished here, which is to render a decision as to this difficult case. That's number one. Number two, I said this to you before. I do my best to try to keep matters calm. And here with some humor here and there. There's no humor in any of this, and everyone knows that. And I think I've said that before, but I say it again now so that you understand. I only do it because I understand the impacts that it has, and I wanted to make sure that you understood, that I understood where you were coming from, and I tried to do that by keeping things calm. The third thing that I want to say is that at this point in time, I now lose control. And when I say that, as you leave here, the courthouse today, obviously, you weren't allowed to know anything about what was going on in the real world as it related to this case for an extended period of time. I want to remind you, everything that happens in that jury room, that's the sanctity of that jury room. That should be left there. I can't force you to not say anything. But I have to make sure that you understand, if for some reason you decided to either to speak out to the media or speak out to anyone else, if you say something there that has an impact on what happened here, then I'm going to have to bring you back, and I'm going to have to question you as it relates to whatever that you may or may not have said. I don't say that to threaten you or in any way. I just need you to understand the truth. That would be something that I would need to do to make sure that that process, that whatever went on in there, only you control what happened in there, and that's it. So I suggest you not to do that. Obviously, you'll be talking to your family and friends, and you can do that at this point. That's no problem at all. But I just remind you of that issue that could come up if you decide to speak to the media. It's publicized, and then ultimately there may be a question that I may have to ask you about that. So other than that, you'll now be leaving. I want to say thank you. I appreciate all of your time. If I'm the lucky one, maybe I'll see you in 3 years when I send you a new notice to come back. Otherwise, I really appreciate all your time and effort. Thank you very, very much.
So not only does he have corny jokes, he's a hater too. He like don't he like don't go out here doing no interviews because you say the wrong thing. I may have to bring you back in here because they're gonna think the jury was tainted. Oh boy, he's so corny. Sparky, get it in. Dang, Sparky. Yeah, I think it's May 12th, Derek. Okay, so they filing out of the courtroom. I don't know if they gonna show us handcuffs or not. Let's see. Well, I guess no, Derek. Oh no, yeah. Oh well, depending on how they do their sentencing. Sometimes they let them come to court after sentencing instead of orange with something else. Why he still standing? I don't know what they waiting on. I'm trying to see. Run, Forrest, run. I'll be running. Hmm. I don't know what he doing. I'm assuming that they still waiting for people to go out. Yeah, Sparky done said something to him. There they go again. I'm trying to see if they gonna handcuff him. Okay, here we go. Here we go. Get the gloves on. Act like you about to do. I don't know. You need all of that to handcuff somebody. Make sure that they ain't doing no drainage search. Y'all, they can do that in the back. Okay, here it go. You got the yellow ones. I mean, what he decided to do was straight stupid. Okay, so they back looking at the ceiling. Yeah, he about to do his perp walk, John. They ain't gonna show it to us, but he sure about to be jangling. That's what he about to be doing. He about to be clicking and the clacking. Okay, cool. So I'm about to take us back into our what we were doing before in regards to our charge conference. They are on break. I'm assuming, the jury was supposed to be back at 2:30. It is 2:38. So I'm assuming our closing statements will start soon. If you did not hear me before, I said that I opened up another room for the closing statements just so we can have the closing statements by themselves. And so as soon as I see that the closing statements are started, I will drop a link in order to teleport you out. Wait a minute, I'm hearing sound. Oh, that's I don't know what that is. I'm all in another thing. Okay, so here we go. I wanted to make sure it wasn't our other trial. I'm gonna go ahead and play this, and we'll hear the rest of our charge conference. It's not much longer. Okay, well, that didn't work out well as far as that. Here you go, guys. I am going to give you the link for the closing arguments if you want to jump on over there. Only because I want to kind of send out a notification, and this is the only way I can really. I don't know how to send out a notification. To kind of let people know. So here they are back. They are about to start closing statements. So I am going to get us over there. So everybody can watch them. So whatever else they were talking about over here, I guess we don't need to see. If you're anything like me, let me go ahead and get that out to you guys. I have no clue what I'm doing here. Okay, so here's the link. If you want to come over, if you click on the link, it will take you over into closing arguments. We will begin closing arguments over there. And I'm going to shut this room down. That way I can have a good room for our closing arguments. What is going on here? Okay. Okay, guys. Hopefully you are getting the link. The link don't work. Wait a minute. Let me get you a new link. I don't know why it's not working, but let's see. I'll get you a link. Don't worry. I got you, baby. Oh, I know why it's the same link, because I gave you the same damn link. That's why I gave you the link. I gave you the same link. Y'all are absolutely right. There go the link. The link kept you right here. There go the new link. The new link should work. Sorry. My bad. Players be messing up too. The player messed up. I'm not a player. The players messed up too. So that is the new link, and that should take you to the room that you should be in. I took the link from the last room. I don't know what I was thinking. Okay, and I see everybody moseying over here. Everybody is kind of getting over here. It should take you over there. No? Oh, okay, because I'm like, no, still nothing. I'm sorry. All right, guys. Well, I will see you over there for closing arguments. I am going to shut down this room, and we will see you over there. Peace.